Matter was urgent for more than 4 occasions. Saturday,
tomorrow. ಬರುತ್ತೆ ನೋಡೋಣ. Good. Tomorrow. All fresh matters tomorrow.
Number 33.
Just wait.
This one, page number 1, number 1 to 12, page number 2, 13 to 18, page number 3, 19 to 21, page number 4, 22 to 29, 27.
27. You appear for. Have you informed the other side? No. Have you informed the other side? I'd request this the matter next week.
Page number 5, 30 to 33.
After the petitioner, 33. In the previous occasion, the court asked to bring the records from the call for records from the government. I think it is not. Let it be listed after mediation.
Hold on.
Because
ಇನ್ನು ಒಂದು ವರ್ಷ ಆದ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ 2012 ಮ್ಯಾಚ್. When do you? Let us see. 29th. ನೋಡೋಣ ಅದು ರೆಕಾರ್ಡ್ ಫಸ್ಟ್ ಬರ್ಲಿ. ರೆಕಾರ್ಡ್
and even the relationship executed by the respondents.
Let us see.
29th.
The fifth.
Page number 6.
ಅಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ, ಅಟ್ಲೀಸ್ಟ್ ಅವತ್ತು ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ರೆ then I'll come.
Page number 6, number 40, number 12, 41.
You take out notice.
The CND brand already the petitioner has exceeded the pleading applicant in the court committee manner. Their respondent number 8 or 9 filed the application for unauthorized occupation.
So what is the mandamus case?
Mandamus brand the appeal, revenue appeal pending before the Assistant Commissioner for the continuation of the revenue entries. Revenue entries discontinued from the 2002 manner. Their request before the Assistant Commissioner.
Now you have filed an appeal, RA 447.
447.
So it will be disposed now.
Yes, sir.
Then what is the relief you are seeking now?
Relief, the first relief, that is the issue direction to the Tahsildar, the endorsement first prayer. That is not required. He has issued the certified copies the subsequently. Second prayer is only the revenue appeal is pending for the commissioner, pending from 2018. That may be direction to the Assistant Commissioner to dispose their application by the appeal.
That's all.
And the C&D, already the petitioners have implemented before the tribunal committee already as the implementing applicants. And the very.
Then you find out how much time will be required for disposal of the appeal.
147 bar 2018.
When do you want it? Onal kelpidi. Just find out. It's a 2018 RA. Next week we'll have. EG accepts notice for respondents. 1 to 7. Notice to respondent 8 and 9 is waived.
8 and 9, Milan.
Is waived in light of the limited prayer sought for by the petitioner is only as regards disposal of the appeal in RA 447 of 2018. This is the matter in preliminary hearing list on 29th. The old one you have to file an appeal. ಹಳೇದು ಅಪೀಲ್ ಆಗ್ಬೇಕು.
ಅದೇನಾಗಿದೆ ಲ್ಯಾಂಡ್ ಏನ್ ಮಾಡಿರ್ಬೇಕು
That is 1970. Which year? Earlier entry is which year? 1974. You have to challenge that. How you can remove that name by way of representation?
land which was sold to them and they have already sold to some other person.
Correct.
Only continue their name.
You have to challenge that entry. How you can give a representation?
We have approached them and but since they have no documentation them and since they have sold to them and
That you will have to file an appeal only. That is the only remedy. How can they consider a representation and delete the earlier entry? It's not possible unless you do under 136(2).
it's a delay in coming the way of
That you explain it and grant you liberty.
approach 5 ಕ್ವಿಂಟಲ್ ಮಾಡಿದ್ದಾರೆ 2 ಎಕರೆ ಮಾಡಿ 5 ಕ್ವಿಂಟಲ್ ಸಿಂಗ ಮೆಸೇಜ್ ಮಾಡೋದು 2 ಎಕರೆ ಮಾಡಿ ಕಟ್ ಮೇಲೆ ಇದೆ ಮತ್ತು ಬಿಡ್ತಾರೆ ಫ್ಯಾಮಿಲಿ ಇಂಟರ್ನೆಟ್ ಫಾರ್
Shanta Bai's name was
the wife of
No.
No,
her name. Her name.
They sold the property to Ramrao.
I am asking Shanta Bai's name, which is the MR that is now standing.
She's the wife of Ramrao. Bimrao. Wife of Bimrao.
Which is the entry in her name?
Here, madam. That is in by the man. Next year, madam. Shanta Bai in case Bimrao. Next year, Shanta Bai in case
That is MR number
my number
H9 of 20.
2021.
Now you want that to be deleted,
Yes,
isn't it?
Yes, sir.
So I'll give you liberty, you challenge the correctness of the petition.
That partition the property, even though they have sold the property.
Correct.
We don't know there.
136(2). Homeshekad ಏನೇನೋ strategy ಇರುತ್ತೆ. Petitioner has sought for issuance of writ of mandamus to direct respondent number 2 to consider representation dated 9/8/2023.
It is not extended. What are
Enter the name of the petitioner,
It's a family member.
petitioner's family in respect of land bearing survey number 5/1. Now new number 5/1A measuring 2 acres at Chikkanhalli village, Sompura Hogli, Nelamangala Taluk, by deleting the name of Shanta Bai. It is noticed that the mutation MR H9/2021 has been effected in the name of Shanta Bai wife of K.H. Bhimrao. And it is a case of the petitioner that the name of the petitioner's family is required to be entered into by deleting the name of Shantabai. It is to be noticed that once an entry stands in the name of the said Shantabai, the only remedy available for the petitioner is to challenge the said mutation standing in the name of Shantabai by way of appropriate proceedings under 136(2).
136.
Accordingly, the petition is disposed of, granting liberty to the petitioner to take appropriate action to challenge the revenue entry standing in the name of Shantabai in accordance with law. All contentions are kept open. EG accepts notice for respondent 1.
Okay.
You find out there's already a previous order. I'll have it until
But already disposed.
and disposal. Which is earlier it
Earlier, selected D,
annexure.
page number 84. Yes,
Same petitions,
not same petition, some other petition, same survey number,
same survey number.
same property, and same survey number. Other criteria. Similarly, there's a criteria. This order already implemented by the authority.
Implemented.
Everything what is pressure or representation in account.
Petition. It is not a government education. The present petition has been filed seeking for issuance of writ mandamus to direct correspondence to consider representations annexure F, F1 to F25, seeking incorporation of revenue entries in respect of land in survey number 14 of Kutlu village, Kavrikere Hodli, Magdi Taluk, pursuant to the grant certificate at annexure A series. Petitioner submits that land has been granted in survey number 14 of Kutlu village, Kavrikere Hodli, Magdi Taluk, and they have been making several representations for effecting revenue records in their name pursuant to the grant orders. It is further submitted insofar as the grant in the same survey number. Similarly placed grantees had approached this court in WP
344, page number 19.
13446 of 2020, which has been disposed of by directing the respondents to consider the representations. And it is further asserted that pursuant to such direction, revenue entries are effected, reflecting the grant. It is submitted that on parity, same direction as in WP 13446 of 2020 may be passed in the present case. Taking note of the limited prayer sought for relating to affecting revenue entries pursuant to orders of grant and noticing similar direction passed in WP 13446 of 2020, the petition is disposed of directing the respondent number 4 to dispose of the representations of the petitioner at the lecture F1 to F25 expeditiously. If if the authorities come to a finding that the representation is to be considered in the affirmative, taking note of the action stated to have been made pursuant to direction in WP 13446 of 2020, the fourth respondent to expeditiously take action and consider the subject matter of request as made out in the representations expeditiously. Accordingly, petition is disposed of.
Direction email. This issued not the permission granted not to hold in court. There are number of 150% measuring 110 into 22.
Find out. What is-
Only matter if the xerox has been cancelled because of formal notification. And acquire the land in favor of the housing board. Yes, 2001. Only film notification, no other notification has been issued. Automatically, the formal notification stands cancelled. This notification not issued within 2 years. This is only the reason why they cancelled the permission granted earlier.
But why don't you challenge the acquisition as having lapsed?
Living notification issued in the year 2001. Within 2 years, one final notification has to be issued. If final notification not issued within 2 years, as per the Land Acquisition Act,
But
formal notification stands automatically cancelled.
some declaration must be there.
No declaration.
I'm saying that the landlord must seek for a declaration that proceedings have lapsed. When you find out.
Whether or not after the government notification, whether there is any proceedings.
No, correct, but some declaration must be there.
Only after this one, I seek for declaration. If after the notification, final notification not issued within 2 years. But automatically the film notification stand cancelled. That is the Land Acquisition Act.
AG accepts notice for respondent 1 and 2. This is the matter.
That is not the ground to not they cancel. They already collected money.
Get instruction. Week after next.
We already invested photograph plan.
Let us see. Week
I
after.
already invested money. I already prepared the holding.
Give me the hearing list on 4th.
Originally, land bearing survey number 38 was granted in my father's name.
Find out. They're saying some old number, new number. Where are you reading?
have to challenge the state ignore. He is running over. What are we at? This all has to be challenged in the land. By giving representation, I can see they are not good.
I have produced my artist.
They have to read it. They have to challenge the state law. That's problem.
So now, what the state is saying, that Lokesh, according to you,
I may be permitted, I made a party.
no, correct. What he's saying, now Lokesh has got his name entered, which according to you is wrong. That entry in favor of Lokesh, you have to challenge under 136(2). By now, they cannot.
My humble will happen. The 38 was granted and that was accepted. And subsequently, I request the Honorable Court, Your Lordship, it is a RTC I have produced before the Honorable Court is election. Next D, please.
Annexure
D.
page.
In page number 32, please. Record copy is 33. They have assigned me a new number for 83. Kindly see that RTC or other, they have overwritten 3 na 8 anta avaru madibittu. It is a done by mistake done by
Page
the
30.
32, please, Doctor, RTC. In that, they have overwritten 3 na 8 anta avare tidupittiದ್ದಾರೆ. Without any valid document and any order passed by any authority.
ಯಾವ ಕಾಲಮ್ ಅಲ್ಲಿ?
Top ಅಲ್ಲಿ bottom. Survey number ಅನ್ನೋದ್ರಲ್ಲಿ. The measurement and other is concerned as is intact.
38 ಅಲ್ವಾ?
83 ಅನ್ನತ್ತ ಅವರು 8 ಅನ್ನ ತಿಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. Overwrite it ಅಂತ. Overwrite.
ಅಲ್ಲ 38 88
83 ಅಂತ is they have given a new number. The code number is 38 is one. Code number is 38. They have coded the property and they have assigned a new number. New number is 83.
Where do you get the new number?
They have given a 83 is the new number. It is the code. Code was done, Your Lordship. The mistake ಆಗಿದೆ ಅಂತ my representation has given the Lordship. There is no order. I have filed the application before that regard also, Lordship. With respect to 88 concern, there is no record also. There is no record at all. The same is continued. The same is continued. The father, my father is not aware of that. It will continue. ಹೌದು, ಅವಾಗ ಹೋದಾಗೇನೆ ನನಗೆ ಗೊತ್ತಾಗಿದೆ. When I have approached the, I request the Honorable Court, my representation is in page 42. Specifically, I held the Lordship in second para, last line.
Who is the petitioner now?
The petitioner is a son.
Son of?
Venkatramappa. He is the original branch. After death of my father, Your Lordship, he is not aware of that. He approached the revenue authority. The revenue authority has mutated. But he came to know that the survey number 88 is not the original number, it is 83. When ಅಲ್ಲಲ್ಲ ನಾನ್ ಮಾಡ್ಸ್ಕೊತೀನಿ ಅಂತ ನನ್ನ ತಂದೆಗೆ ಏನ್ ಬಂದಿತ್ತು ನನಗೆ ಗೊತ್ತಾದ್ಮೇಲೆ ಬಿಫೋರ್ ದಿಸ್ ಲಾರ್ಡ್ಶಿಪ್ ಫೈಲಿಂಗ್ ಎ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಟು ರೀಕನ್ಸಿಡರ್ ಮೈ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ಅಲ್ಲ ನಾನೇ ಹೇಳಿದ್ದೀನಿ, ನಾನು ಇಲ್ಲದ ಅದನ್ನ ನಾನು ಹೇಳೋ ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ. ಐ ಆಮ್ not hidden that directly ನನಗೆ ಮಾಡ್ಕೊಡಿ ಅಂತ ನಾನು ಕೇಳ್ಬೋದಾಗಿ.
Include that location.
Please not.
The petitioner makes a oral request for including Lokesh.
Please, sir.
That the request is acceded to. Necessary amendment to be carried out to the past type. AG accepts notice for response 1 and 2. Emergent notice to the newly added third response. No, but what they are saying that if that Lokesh's name is entered with respect to 83 under 136(2), you may have to challenge it, examine it. You may have to challenge correctness of that entry unless Lokesh comes forward and says he has no objection for activity. Let us. Pass over.
Satish, serial number 6. Serial number 6, Satish.
Yes, Mr. Satish. Pass over. Notice will have to go, that's all. They have not challenged. No, he has not challenged. ಅವರೇನಾ ಬೇರೆ ಪಾಸ್ ಓವರ್. ದೊಡ್ಡ ಬ್ಯಾಚ್ ಇದೆ. ಪ್ಲೀಡಿಂಗ್ಸ್ ಮುಗಿಸ್ಬಿಟ್ಟು ವಿಲ್ in 1 or 2 matters you file common objection. In the whole thing, let's see. EG accepts notice, same order. The stay of annexure. Annexure D list along with sales.
Section C, page number 33. When we got the respondent number 2. But the respondent number.
What is the representation for?
Already before.
We'll ask him in terms of 128, isn't it? Lebanese sketch. So if Lebanese sketch is required, you undertake to furnish, we'll dispose it of. Which is that matter yesterday? Yeah, Devdas or Raju, para 7 and 8. Why did you keep quiet for 11 years? Anand Varsha, why did you keep quiet for 11 years?
Before that, we have to file a representative, same representative last year, maybe 3 years back. But that application also not considered the
Petitioner stated to be the has filed the present petition seeking for issuance of writ of mandamus to dispose of the representation at Annexure C. Page
33 laws.
whereby petitioner has sought for effecting of kata with respect to an extent in survey number 20 of Patti Hosahalli village. And Muttukada Halli village, Dodda Belavangala Hogli, Dodbalapur Taluk. There are two gift deeds. So one is in survey number 20 and the other is 9, 10 and 11. The petitioner sought for consideration of his representation at Annexure C for effecting kata with respect to extent in survey number 9, 10 and 12 of Muttukada Halli village, Dodda Belavangala Hogli, Dodbalapur Taluk on the basis of gift deed as well as sought for similar relief insofar as an extent of survey number 20 of Patti Hosahalli village, same Dodda Belavangala Hogli, Dodbalapur Taluk as regards the land transferred by way of gift. So sale deed a gift. Kayakya padidiruttare also by way of gift. Insta. It is submitted that gift deed has been executed with respect to the extent detailed in the table in the representation at Annexure C by Shakuntala on 11/5/2011.
2011.
It is noticed that the extent that has been gifted is portion of the survey number. And accordingly, the third AGA submits that for effecting mutation, the Lebanese sketch may be required. Reliance is placed on the order passed in WP 102325 of 2022. Para 7, full stop. Next, taking note of the limited prayer and also observations made in WP 102325 of 2022, this petition requires to be allowed. Para 7 and 8 of WP 102325 of 2022 reads as hereunder. The petitioner to furnish a Lebanese sketch to be prepared by a licensed surveyor indicating the extent of land that has been gifted. Upon such furnishing of Lebanese sketch and the authority respondent number to take action for effecting mutation in terms of the gift deed in accordance with law. Needless to state, petitioner to comply with all such requirements as may be necessary for effecting of Pata as may be called upon by the respondent thus. G accepts notice for the respondent 1 to 4. List the matter and preliminary list on 5th. You read the endorsement. Just 1 minute. You have filed along with the memo. Endorsement you have filed along with the memo. You have filed. What is the endorsement? Just read. Then you will have to challenge this endorsement. You have to challenge the correctness of this endorsement through separate proceedings. We cannot enter into the. Huh? Yeah. No, correct. You will have to challenge this endorsement separately. The present petition has been filed. Something for issuance of writ of mandamus. Direct respondent number 2 issue endorsement to pay the premium in respect of the land more fully mentioned in the representation dated 16/2/23, 16/2/2023 at NHSC and AGA HCGP has filed a memo and produced an endorsement dated 1/9/2023, which reads as hereunder. In terms of the said endorsement, it is stated that the form 53 has been filed. The form 53 stated to have been filed does not find any reference in the records. And accordingly, the request of the petitioner cannot be considered. Petitioners are at liberty to challenge the said endorsement in accordance with law. All contentions are kept.
But the Associate Commissioner has cancelled the resolution and he has confirmed. The Associate Commissioner is to the right of order cancellation. Addition D1 is very important.
Where is the order?
Deposit.
One not eight E says must be
Then they have to preside over it.
of the no, the member of the Legislative Assembly was not there. He's a part of the quorum. But 108(2) says the chairman, and in his absence, Tahsildar shall
Tahsildar was present, it is clear. In other page, at page 8, Tahsildar Hajari, member secretary, Tahsildar is member secretary. And he is present.
Then you produce the records.
Meanwhile, I request for the matter to discuss with the revenue entity, because RTC mutation has been affected by virtue of regularization of another acquisition. I have been continuing in the position of.
No, correct. Now, if the proceeding goes, it goes. Let us see.
ಬೇರೆ ಅದರದ್ದೆಲ್ಲ ತಾವೇ
If they take any action by the next date, make a request.
respect to submission for us.
I'll fix a date. If they don't come by then, we'll see what is to be.
By the date, revenue entity must not be affected.
No, let us see. If
I have
there,
produced annexed PN.
where is the Tahsildar present?
Please, page 8.
Page?
Page 8. So, number 5 is Tahsildar, Hajar is the one. Only MLA was absent. Hajar. All members are except MLA. MLA has requested to Tahsildar continue with the, he has instructed. That is clear in the.
Tahsildar is present.
Oh, yes, it was present. Sir, what was the
Subject to further consideration, there will be an order for maintenance of status quo regarding revenue entries as on date. Statement of objections to be filed by the state within 2 weeks. This is the matter thereafter.
Because along with 13, but 20,
List along with
13,231 for 23.
birth code.
Grand lottery finder annexure B page number 11, type copy page number 13, what's 3.
Yes. On the 71, they may have de-reserved it. Find out. File. You place it on record, let us. Alert GP. Submit statement of objections will be filed. Statement of objections to be filed within 10 days. This is the matter thereafter. Let us see what it is. For occupancy rate certificate.
Occupancy and khata.
Delist the matter in the same stage on Monday.
Great.
Now, nobody asks for occupancy certificate. So when they ask, at least you must give them some special preference. Yes.
Here, a writ petition was filed in 2019. Lords, this court has directed to conduct the Podi and Durasti within 4 weeks. Lords, as per annexure C, my lords.
Riksha,
C. Order at annexure C, page 11, my lords. Lords, may kindly come to the operative portion. Page 15, my lords, the last paragraph. Page 15. There is a direction to conduct the Podi and Durasti within 4 weeks. May I read notes, para 6?
yes.
Within a period of 4 weeks from the date of order to be passed by the Assistant Commissioner. But what happens here is, when the direction was given, it was submitted that 108K proceedings are pending before the Assistant Commissioner regarding the grant, validity of the grant. And the court directed that once those proceedings are closed, within 4 weeks, Podi has to be done. The next page, lords, annexure D, lords, the proceedings 108K were disposed. Annexure D, lords, next page, page 16. These were disposed on 24/5/2022, lords. Then, lords, from here, within 4 weeks, they were required to do. Lords, under this 108 proceedings, the case was closed, holding that the grant is valid.
Take me to the operative portion.
21, lords, page 21. The impugned proceedings, which is initiated under Rule 108K of the Karnataka Land Revenue Rules, in respect of 13/P6, measuring to an extent of 1 acre 14 unta, situated at so and so, is hereby dropped. Now, lords, subsequently, to implement the order of the annexure C, lords, I issued a notice, contempt notice 86/2023. In fact, a contempt is also filed subsequently on the basis of this. It is pending, lords. In the meantime, lords, what happens? As per annexure F, lords, a letter is written by the Tahsildar, annexure F, page 25. Requesting the Assistant Commissioner to process the, as far as the Tahsildar work is done, lords, he has completed his work by issuing form number 195. It has to be only countersigned by the Assistant Commissioner. The last line, he says, please countersign it and send it.
Has to be done by the Assistant
It
Commissioner.
has to be done by the, it is only to be countersigned, lords, and it is pending, and 3 writ petitions are filed one after the other, lords. Unfortunately, in the first writ petition, when the direction was given, the Assistant Commissioner was not a party. Lords, that makes me to file this writ petition, and it is kept pending. The last date, lords, it is just countersigning and sending to the Tahsildar. In fact, the Tahsildar is ready to do it because he is facing the contempt there. But for this reason, not the contempt petition is also being adjourned for one or the other reason.
Read him out.
The Tahsildar,
AC.
But AC is not a party in that contempt because
You plead him also.
in this writ petition, he is a party.
Contempt.
But contempt, he can't be because the order which I am seeking for implementation, annexure A, C, he is not a party in the earlier rounds.
You say because of his inaction. I'm not.
That, in fact, last date when it was
Monday.
when it submission was made, your lordship said, you just ask him if it is just countersigning, why don't you instruct him to do it? If it is signed, my lords, the process will be completed within a week. Within a week, lords.
The matter on Monday. In the same stage.
It can, if his presence can be secured, or if it is asked, any instruction, so that is
Find out. It's only some countersign.
just
He's already
countersigning.
he's sent it. No, whatever it is, now he has already put up the file. Yes, Monday,
The preliminary.
Monday, same stage.
The land grabbing order. Where what if not wanted to know about 6 properties, my lord.
Good.
6 properties, right? There are 4 properties which are already acquired by the government. Tell him, Lord, I think. But I want to make one submission. Sir, all I'm asking, Lord, is all through these proceedings, whenever the matter is being in an order of meeting. As a matter of fact, even in this proceeding, when the matter was remanded back to Lord, so parties are directed to maintain status. Now, please see what's happened, Lord. So far as 4 properties are concerned, there is no issue because it's already been acquired by the government. So far as 2 other properties, there is 28/5 and 85/1. The person, Lord, and Rekha, who is really defending this proceeding, has alienated both those properties, Lord, contrary to an interim order granted by this court. In 2007, an interim order was granted preventing alienation. In 3 months after that, he alienates that property. And now we've got those sale deeds, which clearly show that those properties have been sold to someone else. And that someone else, Lord, is seeking to exercise rights over the property over which I have possession. So she can't have possession over that property she is holding.
The order passed in.
Passed in 2007, Lord. I'll give you lordship that date. Can I just pass on, Lord, that memo? Can I request Lord to kindly take page number?
So we'll have it on Monday here and pass some order.
Page 6. I know, Lord. I wrote down.
Page 6.
Page 6. This is the order passed, Lord, on 12 January 2007. The Lord will see on the top, 12 January 2007. Please see the next page, my Lord. At page 8. Last part at the bottom, Lord. Considering the allegations that about the respond number 5 in getting the Kata changed, apprehension of the absence appears to be genuine. We deem it proper to direct the pending disposal of appeal. Property shall not be alienated. No charge shall be created on the property hereafter.
Now this person who has sold is respondent in that petition. Respondent number
Yes, Lord. Krishmachari.
R5.
Yes. He is respond number 4 before my Lord. Now, Lord, please see the sale deed of 2007. Whom, Lord, was respondent number 3 in that proceeding. In the order of the learned division bench, respondent number 3 was Srimati Rekha.
She is the purchaser.
She is the seller.
She is the seller.
She is the seller. She claims to her husband, Shankar Narayan Rao.
She has sold it.
She sells a portion of the property in 2007, 23/5/2007, at page 37, contrary to this interim order. 5/2007. My Lord saw the order was January of 2007. When these proceedings were pending, she sells a portion of the property to one Rajesh. And in the same way, my Lord, several properties are sold in from 2007 onward. On 23/5/2007, there are 3 sale deeds selling portions of the property. Now, Lord, those persons also are made parties before the land tribunal. They also appear. Then, Lord, last time when the order was remanded back, when the order of remand was made, the Lord said all parties maintain status. Now, Lord, all of a sudden, an order is passed in this case after recording evidence and holding, my Lord, that there is no tenancy created in favor of our client or my father, my Lord, who was the original tenant of this property in 67 on. And today, my Lord, others are trying to interfere with our possession. On the basis that we have a sale deed in our favor, but all those sale deeds must go in the eyes of law because they were all passed contempt and now Lord recently Supreme Court has held. Any action taken contrary to an order of the court or of court would be a void ab initio. Now someone else comes and makes a claim in respect to that property. When things were at large and there was an interim order, so all I'm saying is please protect me with the same order of status until the Lord, your Lordship decides this question. And I'm sure your Lordship, Lord, there is fundamental problems in the manner in which the order has been passed, quite apart from the order itself. The order was not released till June or July. Till July, Lord, we do not have the order. When the order comes, it's shown as it was passed in March of 2023. Within a week of Lord, the evidence being completed, it simply says 2 days to file it. Nobody filed it. And an order is passed on March 2023. Or nobody knows of the order, even they don't know of the order. They file a caveat in June. Then, Lord, I come to know and make an application, I get a copy of the order.
Have it on Monday. Release the matter in the same stage on Monday. On behalf of the petitioner, memo produced documents is taken note of. Statement of objections filed by R2 to the main petition has also been filed and is taken on record. That order is there. No, I've stated, it's made clear that the interim order is yet to be passed. Accordingly, anything done till passing of the interim order would be subject to audit.
Yes.
Copy there, sir. Where is the rejection? Which is the other application? The other one is pending. Granted. I will look at it. Third AGA submits file statement of objection. This you file with a memo and also copies of Form 50 with respect to survey number 210, which is stated to have been rejected, as well as copy of Form 50 with respect to 209, which it is submitted, has been considered for the say of the petitioner. This is the matter on when do you want? We list the matter tomorrow in same stage.
Are not part. A is not trying to do starts. The orders. Also, I'm producing the orders. Hearing. Petitioners were not made as part.
So what are these proceedings?
Proceedings blood proceedings. Point number one, eviction proceeding. The eviction proceedings as well as after remand by the Karnataka Corporate Tribunal, setting aside the grant on the complaint made by the third party. But the
Take me to the operative portion of Annexure A.
ಬೆಂಗಳೂರು ಉತ್ತರ ಅಪರ ತಾಲೂಕು ಯಲಹಂಕ ಹೋಬಳಿ ಸಿಂಗಾಪುರ ಗ್ರಾಮ ಸೇನಗಳು ಕೋಣಸೋ ಎಕರೆ ಜಮೀನು 2 ಎಕರೆ ಜಮೀನು ಮಂಜೂರು ಬಗ್ಗೆ ಅರ್ಜಿದಾರರು ಮತ್ತು ಎದುರುದಾರರ ಕೋರಿಕೆಯನ್ನು ವಜಾ ಮಾಡಲಾಗಿದೆ ಹಾಗೂ ಕಂದಾಯ ದಾಖಲೆಗಳಲ್ಲಿ ಸರ್ಕಾರ ಎಂದು ದಾಖಲಿಸಲು ತಹಸೀಲ್ದಾರ್ ಅವರಿಗೆ ಆದೇಶಿಸಿದೆ.
This land has been granted to
market value of the property. This was granted in favor of the ex-serviceman. But the annexure C is the chalan for payment of 60,000. Kindly peruse ಆದೇಶ ಈ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಇದೆ annexure B kindly peruse. The annexure B.
It was granted to one Tyagarajan.
Tyagarajan is the respond number 1 in the before the proceeding for Deputy Commissioner. He is no more. He died prior to the order. But is in tested.
But who are you?
I am the purchaser. Kindly peruse. I am purchaser from the petitioner, even as purchaser from the said Tyagarajan. Kindly peruse the document annexure H is the same. The first petitioner purchased the property under annexure H. Pursuant to that ballot, mutation was effected.
Annexure?
Yet, in in respect of 1 acre of land purchased with first petitioner. And the annexure.
Then we'll see now. Okay. They claim that he died on 27/11/21.
Also, ballot, we are not paid as parties. We are fighting against the government. So since from 2014, ballot, we filed an application for the Deputy Commissioner conversion of the land. He knew very well that we are in possession. The RTC extracts produced before this all court clearly show that the petitioners have been in continuous position as a at ballot, kindly peruse, we prepared resolution since the our prayer for the
To find out if it is a fact according to the death certificate. Then since it's an order against a dead person, we'll have to
Also,
set
we are
it
not
aside
parties.
and limit it for questions. Find out, find out. within the time. So correct. If that is so, you can always give an opportunity to him, let him justify whether there is violation of grant or not.
We are not great parties, sir.
Third counsel for the petitioner would submit that the petition is the purchaser.
Good petitioner.
Petitioners are purchasers. The sale deed dated 5/2/2001
Same 25/6/7.
and 25/6.
7. By the second petition.
Where do you get that?
Here, page 80.
In 25/6/2007 is submitted that proceedings before the deputy commissioner have proceeded without making the petitioners as parties, though they are the purchasers and are adversely affected by the proceedings at Annexure A. Further submitted that Tyagarajan, vendor of the petitioners, died on 27/11/21, while the order of the deputy commissioner was passed on 22/5/23. Accordingly, as the order is passed against a dead person, the order at Annexure A has no sanctity in eye of law. Accordingly, there would be an order of status quo as on date.
There is a direction. Enter the name of the government, the revenue record. Accordingly, the acted upon that, it is wanted to be put.
But now that has already been effected,
We are in position kindly peruse malad. Conversion order matter kindly peruse malad the very depend on the respondent.
just wait. Accordingly, there will be an order of stay of the impugned order at Annexure A. Copy of the death certificate is filed along with the memo. Same is taken on record. Statement of objections to be filed, or you take instruction. If you want it to be reconsidered, you find it.
We pass an order of conversion simultaneously in our favor in order to avoid contempt proceeding. Up to Supreme, the matter went up to Supreme Court against the order of the secretary for conversion.
So, but they're saying there's some violation of term of grant.
ಇದೆಲ್ಲ ಅರ್ಥ ಮಾಡಿದ್ರು ರಿಟಲ್ ಅರ್ಥ ಮಾಡಿದ್ರು ರಿಟಲ್ ಅರ್ಥ ಮಾಡಿದ್ರು ಎಸ್ಎಲ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Let us. Yes. You file along with memo the death certificate. Necessary steps to be taken for service of notice on the unserved respondents. Yes. Even in that same, in 18 and 18.1. Yes. Weeks time granted for necessary compliance.
Yeah, 20.
Yes.
Serial number 20, my lord, for petitioner.
Take steps. Take steps.
My lord, I have already given hand summons, my lord. I mean, Tahsildar is interfering with my peaceful position, my lord. Everyone are on record except respond number 7, my lord. I have served hand summons to him. R8 is dead, my lord. His only successor is R7, my lord.
You file a memo to that effect.
I have already filed, my lord. Because now I am aggrieved, my lord. Tahsildar is coming and interfering with my peaceful position. I filed the photographs also, my lord.
Who has died? R7.
R8, my lord.
Where is that memo?
The memo I have given, my lord, last time. On 30th August 2023, my lord.
No, that R8 has died. Have you filed that memo?
I filed along with that acknowledgement of copies served. I have given a memo stating that R8 has been dead, my lord.
No submission. Our counsel for the petition. Counsel for the petitioner signed a memo stating that respondent number 8 is reported to be dead and is survived by the respondent number 7, who is the only legal heir. In light of the said memo, it is ordered that respondent number 7 would represent the interest of deceased R8. Necessary endorsement to be carried out in the past type. Now, what have you challenged?
My lord, I have challenged, I am aggrieved by this respondent number 2's order, my lord, in case number Inam Appeal 3/2002-8-3, it is Annexure J, my lord. I just want the honorable court to peruse J, my lord. My lord, 59, page number 59, my lord. Here, applicant number 1 and 2, my lord, they are none than respondent number 7 and 8, my lord.
Yes.
They are respondent number 7 and 8, and applicant number 3, my lord, he is petitioner's father, my lord.
Yes.
And applicant number 4 is petitioner's brother, my lord. My lord, I just want honorable court to come to page number 65, my lord, in the same impinged order judgment. Page number 65, my lord.
Yes.
Fifth line, my lord.
Yes.
ಒಂದನೇ ಮತ್ತು ಎರಡನೇ ಅರ್ಜಿದಾರರು ತಮ್ಮ ಜೀವಿತಾವಧಿಯಲ್ಲಿ ಮಲ್ಲಸಂದ್ರ ಸರ್ವೆ ನಂಬರ್ 141ರ ಜುಲ್ಮಾ ವಿಸ್ತೀರ್ಣ 314 ಎಕರೆ ಪೈಕಿ 214 ಎಕರೆ ಜಮೀನಿನ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿ ಇದ್ದುಕೊಂಡು ಉಡುಸಲ್ಲಮ್ಮ ದೇವಸ್ಥಾನದ ಅರ್ಚಕರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಾ ಬಂದಿರುತ್ತಾರೆ. ಇವರ ನಂತರ ಇವರು ವಾರಸುದಾರರಾಗಿ ಮೇಲೆ ಹೇಳಿದ 214 ಎಕರೆ ಜಮೀನಿನಲ್ಲಿ ನಿರಂತರವಾಗಿ ಸ್ವಾಧೀನ ಹೊಂದಿ ಅನುಭವಿಸುತ್ತಾ ಹಾಗೂ ಉಡುಸಲ್ಲಮ್ಮ ದೇವರ ಅರ್ಚಕರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಾ ಬಂದಿರುತ್ತಾರೆ. ಈಗ ಸದರಿ ದೇವಸ್ಥಾನದ ಅರ್ಚಕನಾಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವ ನಾನು ಸರ್ಕಾರದಿಂದ ಪ್ರತಿ ವರ್ಷ ರು. 1,100 ತಸ್ತಿಕ್ ಹಣವನ್ನು ಸಹ ಪಡೆಯುತ್ತಿದ್ದೇನೆ. ಮೂರನೇ ಅರ್ಜಿದಾರರು ಸಿ ಕೆಂಪೇಗೌಡ ಹಾಗೂ ಇವರ ಮಗ 4ನೇ ಅರ್ಜಿದಾರ ಸಿ ಕೆ ಕೆಂಪೇಗೌಡ ಎಂದಿಗೂ ವಿವಾದಿತ ಸರ್ವೆ ನಂಬರ್ 141ರ ಜಮೀನಿನ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿ ಇರಲಿಲ್ಲ ಹಾಗೂ ತಾವು ವಿವಾದಿತ ಜಮೀನಿನ ಸ್ವಾಧೀನದಲ್ಲಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ ಎಂಬುದಾಗಿ ಹೇಳಿರ್ತಾರೆ. ಈ ಒಂದು ಪ್ಲೀಡಿಂಗ್ ಮೇಲೆ honorable respondent number 2 as framed points, that is para number 11, my lord. ಅರ್ಜಿದಾರರು ಕರ್ನಾಟಕ ರಿಲಿಜಿಯಸ್ ಅಂಡ್ ಚಾರಿಟಬಲ್ ಇನಾಮ್ ಅಬೊಲಿಷನ್ ಆಕ್ಟ್ 1955 ಕಲಂ 6A ಅಡಿಯಲ್ಲಿ ವಿವಾದಿತ ಜಮೀನಿಗೆ ಆದಿಭೋಗಾದರನ್ನು ನೋಂದಾಯಿಸಲು ಅರ್ಹರೇ ಎಂಬುದರ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ ತೆಗೆದುಕೊಂಡಿರ್ತಾರೆ. ಬಟ್ ದ ಫ್ಯಾಕ್ಟ್ಸ್ ಆರ್ ಸ್ಪೀಕಿಂಗ್ ಡಿಫರೆಂಟ್, ಮೈ ಲಾರ್ಡ್. ಐ ಜಸ್ಟ್ ವಾಂಟ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಟು ಕಮ್ ಟು annexure A, my lord. ನಾನು ಗೇಣಿ ಅರ್ಜಿ ಹಾಕಿರ್ತೇನೆ. ದಟ್ ಈಸ್ ಪೇಜ್ ನಂಬರ್ 17, my lord. Form number 7, my lord. C. Kemperengagowda. I have been cultivating land, last column as permanent tenant or protected tenant for over 40 years. Other translated copy, typed copy, my lord. That is page number 19. My lord, I filed my geni arji and I was a tenant, my lord. But the honorable authority, respondent number 2, has considered me under 6A, my lord. I was not a archaka, my lord. And the honorable authority only, which is, he has mentioned in his page number 67, my lord. I just want honorable court to come to page number 67, my lord. Page number 67.
So just before that,
Ah.
who is the landlord? In your
Landlord
form-
Bandu Udusalama Devasthana, my lord. I made him as respondent number 3.
In your form 7, just point out.
Yeah, my lord. Second page, page number 20, my lord. Page number 20 nalli. First line nalli ide, my lord. Sri Gangadhareshwara ಇವರ ಇನಾಮ್ತಿ ಮತ್ತು ಮಲ್ಲಸಂದ್ರ ಮತ್ತು that translated copy I will read, my lord, because that cannot be read out. In translated copy it will be.
Now the revenue records are in whose name?
Revenue records has been come to my name, my lord. After after Udsalama, once I got there was a tribunal order, my lord, with respect to my application and application of respondent number 7 and 8, my lord. Then that applicant number 4, who is my son, he also filed an application. Then there were 2 orders for the same survey number, my lord. Then there was an ambiguity. Then they were referred to High Court, my lord. In High Court, since there was 2 orders, once again High Court has ordered to go to the tribunal and get all these applications, let it be clubbed and do a de novo trial, my lord.
Where is that order?
My lord, Annexure J, my lord. Annexure, High Court order is Annexure H, my lord. Page number 58, my lord. The petitions are allowed, setting aside the impinged orders in respect of each case, and the matters stand remitted to the tribunal with direction to club all the applications filed by the petitioners herein and give full opportunity to the parties concerned and have a de novo trial and decide the matters in accordance with law.
Now, as on date, revenue is in whose name?
My lord, when I got a kata, it was in my name, my lord. Afterwards, my name was removed out and it was in Udsalama Devaru. It is in temple's name, my lord. Udsalama Devaru temple. In 82, once I got, I had an RTC. That's what, my lord. I just want honorable court to come to page number 67, my lord, where the honorable respondent number 2 has mentioned it. I just want to read that portion, my lord.
Yes.
Yeah. From end, my lord. Second para. ಈ ಬಗ್ಗೆ ಕಡತದಲ್ಲಿ ಲಭ್ಯ ಇರುವ ಮಲ್ಲಸಂದ್ರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 141 314 ಎಕರೆ ಜಮೀನು 1968-69ರಿಂದ 1972-73 76-77 78-79 ಮತ್ತು 84-85ರಿಂದ 86-87ನೇ ಸಾಲಿನ ಪಹಣಿ ಪ್ರತಿಗಳಿಂದ ಕೆಂಪೇರಂಗಗೌಡರವರ ಹೆಸರು ಮಾತ್ರ ಪಹಣಿ ಕಾಲಂ 12-7ರಲ್ಲಿ ನಮೂದಾಗಿದ್ದು 73-74 ಸಾಲಿನ ಪಹಣಿ ಹಾಜರುಪಡಿಸಿಲ್ಲ. So I was the ಅನುಭವದಾರ, my lord. And this is the basic ingredient which is required to get a grant, my lord. ಒಂದು ಮತ್ತು next para, my lord. 1 ಮತ್ತು 4ನೇ ಅರ್ಜಿದಾರರು ಹೆಸರು ಪಾಣಿ ಕಾಲಂ 12-7ರಲ್ಲಿ ನಮೂದಾಗಿರುವುದು ಕಂಡು ಬರುವುದಿಲ್ಲ. This has been observed by the honorable authority. But since he took the application under 6A, I was not Archaka. Based on only the pleadings of 1 and 2.
Let us see the matter requires to be heard. We will direct maintenance of status quo. But their names are found in the RTC from 68-69 to 86-87.
Now, they are on board, provide an opportunity to Already master this sort of that is not done. They didn't issue notice. At one point in time, they realized that all the 70 years they take for the army part. They are not experienced with because any office.
Then I'll stay the impugned order. Let us. The petitioner submits that his application was filed in Form 7, whereas the authority has taken recourse to Section 6A of the Mysore Religious and Charitable Norms Abolition Act and dispose of the matter. In light of the various contentions raised, matter requires consideration and there will be stay of the order at Annexure J. Statement of objections to be filed by the respondent, state to secure the records.
Much obliged.
Where we won the. It is same grant.
We'll follow along with the EG accepts notice. No, the CGP accepts notice. With respect to respondents 1 to 7, notice to respondent 8 and 9 is deferred in light of the limited prayer sought for as regards disposal of appeal RA 446 of 2018, list along with serial number 1 on 2029. Office objections. Office objections. Office objections to be complied with by the next page. Some interim order is passed. It stayed. So then you file your objections. I1 of 23 has been filed seeking for dispensation of typed copy of annexure E to E12, F to F4. In light of the undertaking that typed copy will be produced if required at the time of hearing of the matter, IA1 of 23 is allowed. This is the matter in B group. There is no limit till the next date. Interim order earlier granted is extended. The respondents are at liberty to seek for modification of the interim order upon filing statement of objections.
Also,
Himavati. Same order. Himavati channel. Check it. Stay of annexure B list along with so and so. Office objections to be complied with.
Municipal office. To enter my name in the revenue records, I have obtained a sale deed through court, suit filed by me for specific performance. But the suit involved two survey numbers, 14 and 19/2. Insofar as 14 is concerned, they enter my name alone. But as far as 19/2, which is about 3 quintas and 12.5 quintas, they don't enter minutes.
It's a portion of the survey number.
Portion, annexure A, is a sale deed, the court sale deed.
Serve a copy. Serve a copy. We'll dispose it off
Please.
subject to the undertaking that you will furnish a sketch 11E. And then they will take note of it, and we have passed some orders in which the court has stated if it's portion of survey number, you can get a 11E sketch prepared by a licensed surveyor.
Please.
Survey copy will have it tomorrow.
Please.
Subject to this undertaking, have a look at it.
I will.
We'll dispose it.
Please.
Release the matter tomorrow in preliminary hearing list.
Please.
Why do you want 2 weeks? Huh? Why you want 1 week? Amendment, you carry it out. Weeks time granted for filing of amended cost title.
Direction to the Tahsildar to rebuild the grant record. The petitioner has lost the grant certificate, filed several representations annexure KLM. And the petitioner made request 2019, 16/2019, page number 54. And their own government order that and when disposed, the deputy commissioner is the chairman of this committee, and assistant director of land records and Tahsildar are the members of the committee. If any the grant records displays 1 or 2 records, some other relevant records they build up and the recommendation to the deputy commissioner. The deputy commissioner may take the decision, Malad.
It's an old matter. We'll have it next week.
There is a government order, Malad, and the government, the advocate has submitted this matter, page number 9, Malad. When the same government advocate has submitted the records, and the page number, the para number 9, there is an one circular. Para number 9. Similar matter. The land government advocate takes me through the statement of objection, submit that case where the original grant records are missing, government, in order to avoid the misuse of the power by the revenue officials by resorting the
Find out.
yes, 17/9/2009. There is a government circular is there.
Find out. When do you want it? This is the matter. Same stage on Tuesday. They are scared. Devnalli, Bangalore.
No, this is not the Devnad, that. Dottukallapuram.
Let us
And other grant certificates we have produced. The 6th grant is in the same grant. And we have lost the grant certificate.
their names.
Their
Mutation.
name is there.
Mutation is entered.
Mutation is there, and I am the purchaser, second purchaser from the granting plan. Not to-
Find out. If there are other grants, then anyhow, find out.
Other granting certificates we have submitted for relevancy of their grant certificates are available. And my grant certificate, my grant certificate was spares.
Let us. Yes.
Municipality.
Yes.
The subsequent lot contends that it is allotted, granted, and reserved for municipality. That's para number 5 of the affidavit.
Reserved for
My contention, my lord, there were two directions issued by the Assam court to consider my application for regularization of particular land, which is in occupation, my occupation from more than 4 decades. Even before consideration, it appears that an attempt is made to grant this land to municipality. Now municipality wants to come on that.
Now, correct. Now, the only point is if their application, then you cannot grant it to anybody else unless you dispose it. Now, let his application be allowed, but let the state take the stand. Grant counsel for the impleading applicant. That is the Chief Officer, Town Municipal Council, Malur. Submits that the land, which is the subject matter of the present proceeding, has been allotted to the impleading applicant.
Let him furnish the copy of the order.
Right of the stand taken. Application is allowed. Necessary amendment to be carried out. State to file their statement of objections and take their stand regarding the assertion of the petitioner, that is application for regularization, has still not been disposed of. List along with WP number so and so. In some matter, yesterday, in some matter, we have directed. You have appeared in the previous round of proceeding. They were claiming some urgency. I think tomorrow we have listed the direction to serve copy only. Just find out.
From is okay.
Yes, yes.
The mutation is effected on the basis of the child. He has no interest in it.
Okay. Yes, tomorrow. Tomorrow. At 2:30. What is the matter?
I have, my lord, been granted the land. I have been in possession. I have got, my lord, the kata. We wanted, my lord, the e-kata to be named. At that time, they said, e-kata, the Tahsildar recommended. Ultimately, they did not do it. We came before your lordship. Your lordship, my lord, directed them to do the e-kata. They did not do it. We filed, my lord, they did not pass some kind of an order. We filed another writ petition. That writ petition, my lord, your lordship said, in this writ petition, my lord had called for the original record, looked at it, and said, this is what it is. And my lord, ultimately, my lord, your lordship directed them to go to the e-kata. They challenge it in the writ appeal. Writ appeal, my lord, they say, oh, we have some new documents which we are now filing. They file, my lord, the new documents. It has nothing to do with it. At any rate, my lord, their contention today is, there are, my lord, what they do is, the original records, my lord, some paper, my lord, they take it out, produce only a part of it. And they say that, your grant itself is not there and you are not the owner of the land. My kata has been there, my lord, for the last so many years. I have produced all the documents. And now, my lord,
Grant is of which year?
my lord, way back in year 1961, my lord. 62.
Since then,
1911, 1962.
since then,
Yes, yes.
mutation.
Mutation, everything is there.
Since then,
Telecast reach, my lord, since then, my lord. RTC from 68, 69 we have produced.
let us
Yes.
tomorrow. Why was it dismissed? For non-compliant. ಇವಾಗ ಮಾಡಿದ್ದೀರಾ? ಹ? ಹ್ಮ್. The petition was dismissed. In light of non-compliance of office objection as per order dated 19/6/23, the petitioner was permitted to comply with the office objection pending consideration of IA 1 of 23 and 2 of 20. Office has put up a note that office objections have been complied with. Accordingly, in the interest of justice, IA 1 of 23 seeking for condonation of delay in filing application to recall the order of dismissal dated 19/6/23 is allowed. Delay is condoned. IA 2 of 23 is allowed, and the order of dismissal is set aside. Matter is restored to file. This is the matter next week. Yes.
Bank guarantee. My lords, on the last occasion, my lord, your lords directed that the BD and the corporation and my lord, should meet. We met, my lord, nothing came out of it. They said, get the TDR, then we will see what to do. TDRs are not, my lord, if they give us the TDR, my lord, my lord, in that event, my lord, let them, my lord, take the 100% bank guarantee. The moment we give the TDR, the bank guarantee will return.
Now
Because
you find out from your officers. You find out from your officers who you have identified as a person who has TDRs to be conveyed. So then you find out and place. Mr. Holla will manage that. So you find out. So we'll have it on Monday. Delist the matter on Tuesday. So if you get details, you share it. Two thirty. Now one point he has raised in saying 136. You take 136. 136(3). Just read 136(3). Read. One 36(3). What is contending? 136(3) relates to orders under 127 and 129. It cannot relate to grant. That you'll have to, and he relies on that judgment of Justice Arvind Kumar.
And another judgment for Jayama case.
So what he's saying, 136(3) relates to record of rights, that is 127, or 129. That is a mutation. So, except under for these RTC or mutation, you can't say that the grant is bogus under 136(3) is what he's saying. That the jurisdiction of 136(3) is limited only to revenue entries or mutation entries. That he's saying no. He's saying he's saying that 136(3) cannot be expanded to other than 127 entry or mutation under 129. Tomorrow, Saturday. Huh? Saturday, I want to dictate it. Saturday, I want to dictate and close it. So let him
Ravindra Murthy case. Ravindra Murthy case. Ravindra Murthy case. And Jayama case also the issue is covered. And another coordination case. That issue should be coordination clearly. The deputy commissioner has no power to examine the correctness of grant under section 136. Issue is covered.
examine it. If that is so, then under 136(3), you can't enter into validity of grant. Your forum available is the civil court.
This is the reason you should there.
That you examine. That's up to
This is
you.
the reason.
All other power will be kept open. That's ಅಲ್ಲ ಅವ್ರ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಲ್ಲ ಅವ್ರು ಹಾಕಲ್ಲ.
Because number of cases, not only this matter, after the judgment, they withdrawn several matters, more than 800 cases on this issue. Rightly or wrongly, I am the position under section 34 of the specific relief act, I am entitled for adverse provision.
But now the grant is of which year? Now almost 60 years.
One more issue was my yeah, it's 1965 grant. When the grant has taken place, that point of view, the land revenue rule not exist. Land revenue rule is not exist. And land revenue rules also coming to force in the year 1968. The regulation under the this government rule comes under 1970. So we have to go by the recipe what rules right to land revenue rule. When that point of time argument, there is no provision of the grant the land in cash and cultivation and more than 10 acres of that. That is not correct. The issue also covered under the land revenue rule. Section 43H. Next I will give extra knowledge. Land revenue rule. Old Mysore land revenue rule. 43H. Notwithstanding anything contained in the proceedings of this chapter, grant plan for cultivation of the coffee, tea, rubber, cardamom, pepper, and cashew nut may be made any person. Then you should mainly take use the 43H. Then 4, 2, 4. That is separate. 4 class 4. Cashew nut cultivation. In extent of 25 acres may be granted for cultivation by cashew nut provided that the total holding under plantation does not exceed 100 acres. Cashew nut ಕೊಡಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ಅವ್ರು ಕೇಳ್ತಾರೆ. ಅಂತ ಎಕರೆ ಕೊಡಕ್ಕೆ ಬರೋದಿಲ್ಲ.
Look into it.
At that point of time.
Look into it. On Saturday we'll discuss. In ಶನಿವಾರ ರಜಾ ಇಲ್ಲ ತಾನೆ ನಿಮ್ಗೆ? ಮುಗಿಸ್ಬಿಡೋಣ. I've heard it. Since I've heard it, on Saturday I won't have much matters. We'll hear him and you keep those registers what you got yesterday. Delist the matter on Saturday. Otherwise, you want to start today in the afternoon, I can hear you.
Well, a little bit arguing already.
Really know them. I'll finalize it. Saturday I'll dictate. I will not have many matters. What are these connected matters?
It is arising out of a single order, but various persons are affected, not therefore 3 petitions are filed by different persons. But the overall, not the order is, the effect of the order is that not a portion of the land in survey number 85/1, 85/2, and 85/3 of Kanisandra village was treated as a kharab of land for several decades.
In terms of the Akarband.
In terms of the Akarband, even I have produced the Akarband also. In
Which?
respect of 85/3.
Page?
But Akarband is at page 54 annexure. Yep.
No, your pleadings are complete.
But the only thing is, all of a sudden, the Tahsildar passes an order saying that it's a B Kharab land. In fact, a portion of this land has already been regularized. B Kharab, A Kharab has been regularized, and as per the order,
Take me to the Akarband.
Yes, sir. Annexure, yep, Lord. Page 54.
Yes.
Lord, got it.
Yes.
Generally, if I read the columns from the beginning, you notice
85.
page 85. This is the one. Lord.
No, page 54. The first column.
You lordships are referring to this?
Annexure F, page 54.
This portion. Yes.
On the
Now,
first column,
yes.
what is that? 84 in Kannada, is it? 85.
85. 85. ಮತ್ತೆ ಹಿಸ್ಸಾ ನಂಬರ್ ಕಾಲಮ್ ನಂಬರ್ 3 ಅಲ್ಲಿ 3 ಅಂತ ಬರುತ್ತೆ 4ನೇ ಹಿಸ್ಸಾ. Then your lordships will find
7 acres 28 guntas.
7 acres 28 guntas. ಅದರಲ್ಲಿ 4 acres ಅಂತ ತೋರಿಸ್ತದೆ. 4 acres is A Kharab land. ಅಲ್ಲಿ ಕೆಳಗಡೆ BA ಅಂತ ಬರುತ್ತೆ lordships got it.
Yes.
ಅದರಲ್ಲಿ 4-0 ಅಂತ ತೋರಿಸ್ತದೆ ಕನ್ನಡದಲ್ಲಿ.
Yes.
That is A Kharab land. Your lordships are able to find it.
Yes, yes.
ಮೇಲೆ ಕಾಲಮ್.
Yes.
ಆಮೇಲೆ ಅದರ ನೆಕ್ಸ್ಟ್ 5B ಅಂತ ಬರುತ್ತೆ ಪ್ರಿಂಟೆಡ್ ಕಾಲಮ್. ಅದ್ರ ಕೆಳಗಡೆ 12 ಅಂತ ತೋರಿಸ್ತದೆ ಕನ್ನಡದಲ್ಲಿ.
Yes.
This 12 guntas is the only extent of Kharab land in this survey number. As per this Akarband, B Kharab land. This is a road Kharab. And even in the RTC, this 12 guntas is shown. Now, all of a sudden, Lords, this order, under this simple order, The Tahsildar says that in survey number 85/3, the extent of Kharab is shown as 1 acre and odd quintal. Your lordships will kindly come to the order now at page 49.
Yes.
Page 49. In this order, Lord, the reference is given to 3 survey numbers. May I read, Lord, Vishaya anta page 50 alli?
Yes.
May I read, Lord? Vishaya, Bengaluru Purva Taluku, PR-ಪುರ ಹೋಬಳಿ ತಡಿಸಂದ್ರ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 85/1 ರಲ್ಲಿ ಒಟ್ಟು 1 ಎಕರೆ 26 ಗುಂಟೆ, ಸರ್ವೆ ನಂಬರ್ 85/2 ರಲ್ಲಿ 1 ಎಕರೆ 26 ಗುಂಟೆ ಹಾಗೂ 85/3 ರಲ್ಲಿ ಒಟ್ಟು 4 ಎಕರೆ 12 ಗುಂಟೆ, ಜುಮ್ಲಾ 7 ಎಕರೆ 24 ಗುಂಟೆ ಖರಾಬ್ ಜಮೀನಾಗಿದ್ದು, ಸದರಿ ಬಿ ಖರಾಬ್ ಸರ್ಕಾರದ ಹಿತದಲ್ಲಿರುವುದರಿಂದ ಒತ್ತುವರಿಯಾಗಿರುವ ವಿಸ್ತೀರ್ಣವನ್ನು ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 1964 ಕಾಲಂ 94 ಮತ್ತು 104 ಅಡಿಯಲ್ಲಿ ತೆರವುಗೊಳಿಸುವ ಬಗ್ಗೆ. Now he says,
but it's better that they put it in writing. Let us see under what power they have
primarily not the
converted.
Tahsildar has no power to pass this order. Primarily, it is without jurisdiction. Secondly, assuming for a moment, Lords, there is any kind of Kharab, it is your lordships kindly come to this. I'll take only 2 minutes. Annexure G, your lordships kindly.
So now he has said, recorded a finding that there is some encroachment.
Encroachment ಅಂತ ಹೇಳಿದ್ರೆ ಇವ್ರು ಏನಿಲ್ಲ, ಅಲ್ಲಿ ಮನೆಗಳು ಶಾಪ್ಗಳು ಆಗಿ 20-30 years ಇಂದ ಎಲ್ಲ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. They have in fact portion of the land they have themselves regularized as per Annexure J, treating it as a Kharab land, and a new a apartment complex has come there. Iskella development ಆದ್ಮೇಲೆ after about 5 decades, on the basis of this Akarban, all the actions have taken place. After 5 decades, the Tahsildar issues one notices. This is Tadisandra main road lot and says that idu B Kharab land, A Kharab alla.
Where do you get that?
That is the finding your lordships will find at page 50, Lords. I'll read only. And namu notice illa. They say that ADLR inda nanu report tarskondidini. They say it is a B Kharab. Therefore, all of your encroachers you have to be thrown out. Your lordships will find that at 4-5 lines at paragraph page 50.
You were not heard.
We were not heard. None of us were heard. In so far as the petitioner in this case, he was not heard. So shop owners getting notice there, but otherwise, before that report from the ADLR is secured, we were not heard. Your lordships will find. May I read notes only 3 lines, page 50.
Page
50.
Yes.
Impugned order, Lord. ಪ್ರಸ್ತಾವನೆ ಅಂತ ಇದೆ. ಪ್ರಸ್ತಾವನೆ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು KR-ಪುರ ಹೋಬಳಿ ತಡಿಸಂದ್ರ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 85/1, 85/2 ಮತ್ತು 85/3 ರಲ್ಲಿ ಈ ಕೆಳಕಂಡಂತೆ ಸರ್ಕಾರಿ ಬಿ ಖರಾಬ್ ಜಮೀನು ಇದ್ದು, ಸದರಿ ಖರಾಬನ್ನು ಪ್ರತಿವಾದಿಗಳು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿದ್ದರಿಂದ ಸದರಿ ವರದಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ತಾಲೂಕು ಸರ್ವೇಯರ್ ಅವರು ಈ ಕೆಳಕಂಡ ಕೋಷ್ಟಕದಲ್ಲಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. I'll pause for a moment. ಈ ತಾಲೂಕು ಸರ್ವೇಯರ್ ಈ ವರದಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾವಾಗ ಕೊಟ್ರು, ಯಾರು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿದ್ರು, ಈ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಕ್ ಮುಂಚೆ ನಮಗ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದಾರ, ಹೂ ಆರ್ ಇನ್ ಪೊಸಿಷನ್, ನಥಿಂಗ್ ಇಸ್ ದೇರ್. ವರದಿ ಕೊಟ್ರು ತಾಲೂಕ್ ಸರ್ವೇಯರು, ಇವ್ರು ಇದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ ಫರ್ದರ್ ಇದರಲ್ಲಿ ಈ ವರದಿಯಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಕಾಲಮ್ 1, 2, 3 ಇದೆ. ತಡಿಸಂದ್ರ ಗ್ರಾಮ 85/1 ರಲ್ಲಿ 9 ಗುಂಟೆ ಮಾರ್ಗದ ಬಗ್ಗೆ, ಬಂಡೆ ಖರಾಬ್ 1 ಎಕರೆ 17 ಗುಂಟೆ. I will insist upon Lords, kindly note this point that bande kharab anta heltare, because I will take your Lords, what is a bande kharab is actually not a B kharab. I will refer to the rules, Lords. Bande kharab 1 ಎಕರೆ 17 ಗುಂಟೆ, ತಡಿಸಂದ್ರ ಗ್ರಾಮ 85/2 ರಲ್ಲಿ 9 ಗುಂಟೆ 1 ಎಕರೆ 17 ಗುಂಟೆ, ಒಟ್ಟು ಖರಾಬ್ 1 ಎಕರೆ 26 ಗುಂಟೆ, ತಡಿಸಂದ್ರ ಗ್ರಾಮ 85/3 ರಲ್ಲಿ 12 ಗುಂಟೆ.
Survey report placed.
Survey report has not been part of the record at all. They are not placed, nor it is served on me, nothing. Nor any notice is served on me before conducting this survey, alleged survey by the ADLR.
Is it
ಯಾವ ಸರ್ವೆ ಇರ್ತದೆ ಸರ್? ತಾಲೂಕ್ ಸರ್ವೆ ಇರ್ತದೆ.
2-1.
ಏನ್ ನಂಬರ್ ಹೇಳಿ?
It's good.
ತಾಲೂಕ್ ಸರ್ವೆ. ಯಾವ್ದು election ಹೇಳಿ? Election B.
In any one of the matter you have filed objection, no? Which matter? 1-5? No, then you have a look. I'll pass over. It doesn't. I'll pass over. We don't have much matters. Whatever objection filed. Will be,
Other matter.
it will be
I will
common.
look
Common. Have a look at it.
In fact, it's the same impugned order
It's
and
a-
all the three petitions.
Fine. Okay, then I'll pass
I
over.
will go through that.
In case you want time, I'll adjourn. If you can manage, we'll take it up. We don't have much matters. Post lunch, if you find you can make out a case, do it. Otherwise, I'll adjourn.
But otherwise, primarily.
No, let us see.
Rule 21
No, we'll have a look at what
ಈಗ
objection.
ಅವ್ರು ಹೇಳೋದು ಬಂಡೆ ಖರಾಬ್ is not a ಖರಾಬ್ at all as defined under the act.
We'll see what stand
I
there.
will do it.
Pass over. If required, I'll adjourn it. But if you, yes. Yes.
Order of the Assistant Commissioner, Annexure M. But the Assistant Commissioner are under one, but without there being any provision, based on some complaint, has held that it is a government land, but I am the petitioner, is a tenant, he was a tenant, but under the 1976.
No, what has happened to the objections to be filed?
They request, madam, one request, madam. And with respect to submission, objection may not be required because this is a third round of litigation. All records are here. What happened was not in 1976, we filed a form number 7. Occupancy rate was granted in our favor, and form number 10 was issued as long back as in 1982. Then, BDO, the block development officer, tried to form a layout in this land on the plea that they are the Ashra layout, they are forming the layout. We challenged that before this on a writ petition. In the writ petition, this on report directed us to approach the civil court. We filed a civil suit. In the civil suit, in that first instance on technical ground is dismissed. Ultimately, this on report set aside the matter to the trial court and to give finding whether I am the owner or not. The trial court looking into all the revenue records and the 1970, we are there tenant from 1940s. Record taking into consideration all these documents declare that we are the absolute owner of the property. This is one aspect of it. In the meanwhile, some third party filed an application before the Assistant Commissioner stating that my RTC entry has to be cancelled. And the Assistant Commissioner passed an order cancelling my RTC entry. That I challenged before the Deputy Commissioner. Deputy Commissioner confirmed it. I approached this on record. This on record directed, when the civil decree is there, how can you do it? Reconsider it. Ultimately, in the second round, the Deputy Commissioner looking into the records and other things, and also there was a COD report. But some third party, the person who has approached this court, has filed a complaint before the Honorable Chief Minister. Chief Minister directed COD inquiry. COD inquiry report in detail. He has submitted this a land reforms. He was a tenant under the Land Reforms Act. Tenancy was granted in his favor. Therefore, some officials, because of various reasons, this is they have been doing all these things, and he has directed even disciplinary inquiry as against them. And report was submitted. Taking into consideration of all these things, Deputy Commission held that I am the absolute owner. This one stage was this, and civil court decreed in my favor. In the meanwhile, one more gentleman, he filed an application before the Assistant Commissioner saying that you have to cancel this entry again. And Assistant Commissioner looking into all these things, he said, no, Deputy Commissioner has said, Civil Court has taken a view, and ultimately the Honorable Chief Minister, everything is said that they are the owners, I am not holding any inquiry, dropped it. And all of a sudden, very, in a week, Malad, last week kindly come to now, annexure, but I will give the, please take the last annexure at page 195. Shall I give one, I'm prepared with a lot of, there are several proceedings, but from 1982 we are fighting. Please see page 195. In page 195. But this gentleman, he filed a complaint before the Assistant Commissioner. And Assistant Commissioner, he has refers all these, the earlier proceeding, even the Deputy Commissioner order, and all these orders he has referred, and ultimately you will actually kindly come to, this is the view taken by him at page 198. Even 136 also dismiss all these things he finds. And please see, in the 198, before one line, 197, the sentence will be written material. Under 136 too, last may kindly see 197. Under 136, read section 25 of the Karnataka Land Act, subjected land therein were converted land. And this was further taking into consideration of other proceedings in regard to the subject land before the legal. The converted lands are out of domain of the proceedings conducted under section 136(2) of the appeal has been dismissed. Since the instant proceedings has been initiated upon the complaint, it is very much independent of the revenue appeal proceeding. The complaint is taken into consideration. Hence, complaint is made in regard to the protecting the government land. Document made available in the revenue appeal bearing number 2 is also taken into consideration in order to ascertain the veracity of the complaint. But this 83 is the order passed by the Deputy Commissioner. Deputy Commissioner order, he wants to overlook that order. Please see, upon perusal of the document, it reveals that Old Survey number 2 cumulatively consists of 35 acres, excluding 4 acres of Kharab land, and out of which an extent of 15 acres, 14 guntas have been converted for non-agricultural usage, and remaining 19 acres, 20 guntas were remained as agricultural land. It is pertinent to note that there are no relevant documents are forthcoming in order support the title claim of the private individuals claiming title in respect of 19 acres 26 of agricultural land. Claim of essay demonstrate claim is nothing but fictitious. In the light of the above observation, Tahsildar of Bengaluru Taluk, South Taluk, Bengaluru is hereby directed to file appeal under section of the Karnataka Land Revenue Act to claim the title of the government land and also file an appropriate appeal challenging in regard to the extent of 15 acres 14 converted land and further directed to maintain the revenue record in the name of the government to the extent of it. But this will have to be created in the first page. Very clear, page 195. But this is against the first respondent and second respondent. This is first and second respondent. But this is the very same officer. Please see the name of the officer. And the very same officer, but I will actually kindly see 194. Next page only. There only. 195 is the order. 194. Very same officer. Very same officer. See the page 191. Order starts from 191. In a week, Murat. This is not how he has done it. Page 191, Anakshadiyal. And again, the same person, Channappa, same person, Channappa, Munir, same person, he says, please see page 194, what is his observation? The petitioner has filed, but this is the order dated 28 July 2015. This order is dated without any notice and nothing, 3rd August 2016. Within 10 days, 15 days. This is the observation he made. The petitioner has filed.
So now you take me from the beginning. You take me to your synopsis.
Yes, right. But this is how Murat he has dealt with it. And this see, I will take it first. Now this. But in 1976, please take this here,
No, let us see if required. If the material on record is sufficient, we'll have a look. No, he's a politician now. Officer is a politician now.
Yes, yes, yes. Not only that, but he was arrested and all these things because of small amount, about 8 crores or something.
But they gave ticket to him.
So yes, and 8 crores, I do not know how he has been caught free and he contested. This is a big political. See what situation.
He lost.
And
Lost.
all these things must have gone.
Huh? Nothing, it doesn't matter. Something has happened with the money. Yes, take me through.
1976, right?
In 1 week, how he can change his opinion? July, last week, clearly shows some malafide.
Total malafide, totally malafide. And I will not trouble you lot by taking all these land reforms, other orders, because that is an admitted fact. It's not in. It could I will take from Lordship candidacy on force, page 2 onwards to Lordship candidacy. Other things 1981, I just for reference purpose I have written because I did not want to upload these facts. 4/6/1982, form number 10 was issued under the Land Reforms Act. The occupancy rate was granted in favor of the petitioner number 1 and father of petition number 1, petitioner 1 and 2, and father of petition number 3. Occupancy rate was granted. From 1992, Black Development Officer tried to form the layout in our property. And we filed a writ petition. Challenging the order pass, challenging the action of the BDO. So you may kindly come to page 25, annexation A. And one by one I will take you. Page 25 of annexation A. But we are starting from 1982 onwards. This is Laship got it.
Yes.
Yes. Page 25, same Chanappa, these are the parties, filed a suit, filed a writ petition against the state. Page 25,
Yes.
against the state. Ultimately, this honorable court, of course, made an observation at page 26 regarding the land reforms orders and everything. Land reforms order has been narrated here. Form 10 has been issued. Then ultimately, court found that it's a civil dispute. If his video is trying to interfere with purpose, file a civil suit. Page 28. In page 28, the last paragraph, I will not trouble you. Para 5 may continue. From the facts of the case, it is clear that there is a serious dispute as to the possession of the land in question. So also, the entries made in the Pani extract and all other documents without expressing any opinion on the rival contention, petition is disposed of directing respondent that if the petitioners are unauthorized position, initiate eviction proceedings in accordance with law, whereas if the petitioners feel that the respondents cannot interfere with their peaceful position, they are at liberty to approach the competent court for necessary relief. But this is the order passed by this honorable court. Then, this video, the state filed a writ appeal challenging. The writ appeal was filed by the state challenging this order that was rejected by the honorable division bench. That is larger that is available in the civil proceeding. Then after the disposal of this one Mr. Kailash filed an RA, but that is before the assistant commissioner. I do not know, he is a third party, claiming as if he is a public interest person. Filed an application for the assistant commissioner saying that it is a property, government property, therefore cancel the mutation entries. Then in the meantime, it is also submitted a complaint to the honorable chief minister, saying that this is the extent of land they are unauthorized occupation, and the land reforms order is illegal, and all these things he has made an allegation because he is having some grievance. He wanted to purchase some portion of the land because there are poor agriculturists. He wanted to mobilize the land, and this man and the latest man who has filed this, they wanted to mobilize the land. They refused. All these are all small agriculture, and they refused. Then he filed a complaint even before the honorable because he is having some. Then the Honorable Chief Minister directed the COD inquiry, hold an inquiry, find out whether really land reform order is there or not, or fabricated, and the judge has directed that. Then the meanwhile, the State Commission, what he has done is, he set aside the entry. This series on 7/10/1985, the order itself I mentioned. Page 300. Page 3 itself. I have given this here, and the order was set aside, this revenue entry was set aside. Then, but I challenged that before this on before in the writ petition. And the pending, the COD inquiry was conducted, and they submitted a report. And when the report came in, then immediately I filed a suit.
What happened to the writ petition?
Petition was allowed by this honorable court. And was remanded to the Assistant Commissioner to relook into the matter. On page 50, in page 50.
This is the order of the ACA.
Yes, sir, that's correct. That is the writ petition was allowed. Matter was remanded to the Assistant Commissioner and Assistant Commissioner to reconsider the matter. Page 50 may kindly. Page 50. There is a reference also in this. Lordship may kindly see page 51. In page 51, there is a reference on this. Lordship. Against this order, respondent agents Chennappa and as well as Munirappa and Chennappa required writ petition number 2 for the Honorable High Court of Karnataka. Honorable High Court in order dated while making certain amendments. This is the order set aside and sent it back. And he has considered, he has passed, he has taken into a lot of documents, so many things he has looked into, and ultimately he comes to the conclusion that he has also again Marathi held on is on 24th April 2000. The Assistant Commissioner and directed the Tahsildar, he has allowed this appeal and directed the Tahsildar to take possession. That order we have challenged before the Deputy Commissioner again. Lordship will get it page 50, page 50. Last order, Lordship may kindly see at page 73. Lordship got it, sir? Yes. This order we have challenged before the Deputy Commissioner under section 136. 3 of the page, this is Annex E, page 75. And the Deputy Commissioner confirmed the order of the Assistant Commissioner. Revision petition was dismissed. Against that, we prepared a writ petition before the time. That is writ petition, the Annex of page 86. In the writ petition, this honorable court made an observation. Please see page 91.
Subject to the OS.
Yes, the meanwhile, we filed an objection, original suit, and we have obtained an interim order also. Directed the government not to take possession, not to dispossess us from the premises.
What happened to that suit?
Suit is secret in the matter. Originally, what happened was we could not produce certain document, revenue record, because they're all hostile. They refused to give the document. Brought to the notice of this, these are all the things. Then direction was given to them. I will send it back to the trial court. You produce all the records before the trial court. And all the records ultimately they produced it. We also produced. The State Commissioner examined as DW1. We have examined witnesses, produced all several 96 documents we have produced. Trial court has decreed the suit. And that reached finality. That was not challenged by the state.
Suit for?
Suit for declaration and injunction. The declaration of title. But that suit also I produced. At page, you last may kindly come. The judgment of the trial court at page 171. Page 171. Lordship may kindly see the parties I find this as against the state, page 112 is the first page. 111, 112. And state is the part, state as well as all are parties. And decree, I find the suit for declaration and for injunction. Please, that may kindly see the prayer what we thought is at page 113. The above suits have been filed by the plaintiff for the relief of declaration declaring that plaintiff is the absolute owner of their respective suit scheduled property and consequential relief from perpetual injunction against the government authorities and for other relief. This is the relief I thought.
This is the suit filed by the petitioners.
We filed a suit because as per the direction of this honorable court, our remedy was only before the civil court. Court has directed you go to the civil court. And we produce all these things and court has decreed the suit in our favor.
What is the finding in the suits?
For a suit, you will ask me kindly come to page 171. Court has given a clear finding, land tribunal has granted
Just
enough
take me to the finding on the
trial court.
issues.
Issues, will ask me kindly come
At page 120 are the issues.
Yes, sir.
And finding is at 123.
Yes, sir.
Just take me through the issue
Yes,
and the
sir.
finding.
Issue, I will take only. Yes. But the last page kindly see, the relevant issue only will ask.
Yes.
The issue number 1, both the suits. But there are two suits because there are two owners. Two suits were clear. Therefore, issue number 1 may kindly be seen. These are the relevant issues. Issue number 1, you will have to get at page 123. Page 1. Placing title to the respective suitable property on the strength of the order passed by the land tribunal in the year 1979. That is page 134.
So we'll just first go to the findings and the issue.
This is finding. Yes.
Findings.
Finding is an affirmative. Large pay kindly affirmative issue number 1, page 126, but is mentioned.
Yes.
Affirmative.
So the plaintiff proves that they're the
Yes. Plaintiff prove that they
absolute,
are absolute owner of the property.
they were allotted land in
Land by the land
LRF.
tribunal.
LRF.
LRF on 1979.
That is the first issue.
First issue, yes. In detail consider, madam, order, every order has been considered. The order passed by the trial court, but ultimately will ask me.
The title of the state at issue 4 in 715 of 96 has been held in the negative.
That is not 715 issue number 4. Whether dependent on suit is not maintained in your they have taken a contention.
No.
Suit is not.
At page 119.
Whether the dependent to the state of Karnataka is the absolute owner of the property as per. So this is what the defense they have taken.
That is held in the
Negative against the state.
negative.
Yes, sir. Issue number 4 in both the suit and negative. The court held that the government is not a owner. By virtue of occupation, RTC, and land grant, LRF order.
What happened? What happened to this?
Suit decreed. And what happened was, is after the suit is decreed, state filed a petition.
So this has attained finally.
No, it was not challenged.
Not challenged.
Not challenged. But in the meanwhile, what they have done is, state directed the deputy commissioner to conduct one more inquiry.
Under 67 too.
Yeah, not 61, he is directed to hold, but there is no provisions mentioned. They are directed to hold an inquiry again. And the deputy commissioner conducted one more inquiry. And he has referred all these things detailed. And he said no, because the Honorable High Court has held and the civil court has taken this proof and record shows that he is the owner. Therefore, proceedings has to be dropped and all the records has to be changed in his name is to be taken by the deputy commissioner. And thereafterward, This person has given a complaint to the State Commissioner. He said, I have already read into a lot.
Where is that order of the?
Deputy Commissioner. And it's come to the order of the Deputy Commissioner. Is at page, annexure H, page 102. Sorry, but I think there is a numbering also mistaken.
Annexure H.
Annexure H, page 102.
So this 136(3) proceedings,
That is the order, but the typed copy also,
that was dropped.
yes, not drop. Holding that, that is, he says, please see page 110. I will not trouble the Lord's sitting, he has relied upon several judgment, saying that the authorities have no right. Once civil court gives the decree and the competent authority grant the land, it reached its finality. Civil court granted the decree. Therefore, DC has no power under the land. Anyway, your lordship decision was also there. That major judgment your lordship was clearly held. That has been confirmed by you, the Honorable Supreme Court. Division bench confirmed it. Honorable Supreme Court has also confirmed it. 136(3), no power. That
Now,
is,
after this annexure H, what happened?
the annexure H, after the annexure H, this person has given a complaint again. But this, the Hemant Raj who has given a complaint, he filed a public interest litigation, annexure K. He has
Annexure?
challenged what he has done is, the person who has appeared before the State Commissioner earlier, his name is Kailash, and he has instigated another gentleman called one Hemant Raj. He claims to be a public spirited person. He filed a public interest litigation for annexure KP 185. And this Honorable Court, taking note of all these proceedings, but please come to page 190. Not entertain the petition, saying that everything is reached finality. Please see this, page 190. Writ petition, a third party intends to challenge the order related to passed by the Deputy Commissioner. This is the order of the Deputy Commissioner. The parties to the litigation are satisfied with the order. The writ petitioner who was not
So
a
the court
party.
refers to the DC order.
This is DC has said that he has no jurisdiction. Everything is concluded. He is the owner. That order was challenged by this man by way of a public interest litigation. This was rejected by this Honorable Court. Then, my lord, the very same the one Hemant Raj, the same person, filed a complaint again before the Assistant Commissioner, page 91. Please see the next page. After the public interest litigation is rejected, he is the very same person. But it is a clear case of abusing the judicial proceeding. Please see 191. 191, the same Hemant Raju filed a petition before the Assistant Commissioner, same Assistant Commissioner. And he had no option because he produced all the records. And he said, I have no jurisdiction because the Deputy Commissioner has taken this view and the Honorable High Court has taken that he is the owner, civil suit. Therefore, I am not entertaining, he is dropped it. And very
holds that it is private land.
Private land. And within a week, another person, we see the page 195, he is also claiming to be in many matters, this gentleman. He filed another petition, saying that it is a public, again it is a government land. And this Assistant Commissioner, who said earlier he has no jurisdiction, he says, firstly, revenue authorities have no jurisdiction once, and Assistant Commissioner absolutely no power. Ultimately, land tribunal order has not been challenged by anyone. Civil court order concluded. Deputy Commissioner order is concluded.
This is the impugned order.
It is the impugned order.
It's annexure M.
Annexure M is the impugned order. But it is a classic case of abusing the judicial process by some third parties claiming to be the public interest spirited person.
Read annexure M. Read annexure M.
Annexure M.
Now, this is the order, isn't it?
Yes, sir.
Which you have challenged.
This is the order I have challenged.
This is the last of the orders.
Last of the order. Page 180, 195.
Yes.
Please see this. Shall I read it in entire?
Yes.
In the meanwhile, I will also take your lordship to the relevant order which he has referred it. Upon the complaint of so that agriculture land old number so and so, these are all the numbers one. Situated Doddabelle village, Kengeri Hogli, Bangalore South, all of Bangalore has been originally a government land. Certain individuals concocted documents and based on the same were able to obtain certain orders from the court. Hence, sought for proper legal recourse in order to protect the government land. They also sought to maintain the revenue records in the name of government in order to prevent the abuse of revenue records. So this is his complaint. Then the said complaint along with the record have been taken on record and proceedings have been initiated, and since the appeal proceedings also been on the board of this court in RA 283 of 2015-16. But this is the order, earlier order. Please see the earlier order, same order, where he said there's no jurisdiction. Page 191 order. Same order, he refers. The subject land, this court so and so, regard to the same subjected land in old number so and so, and since the notices were served upon the respondent in the next proceeding, but no notice is issued in this proceeding. He says notice has already been issued in that proceeding. I am taking that and passing this order.
You were not arrayed in these proceedings.
No notice was issued to us. What he has done is, he has taken the earlier proceeding, but he has passed the order. He says, I am taking that proceeding on the record and notice has already been served to them. Therefore, I am passing this order. And absolutely no jurisdiction, no provisions also. Under what provision? Well, please see, I will read it again. Posted for orders based on available records and available records, he passes an order. It is complained that land in old number so and so, is originally government land, and certain persons were able to establish a right by concocting the documents and sought for proper legal recourse for the same in order to protect the government land. It is pertinent to note that subjected land in this proceeding is also subject matter of the revenue appeal number 280. Even in the said proceeding, appellate here, he is claiming himself to be a public spirited person, filed the said appeal, wherein he sought for set aside the revenue entries made in the name of private parties and by thus sought to maintain the revenue records in the name of the government, whereas in the said proceeding, as so initiated therein, is under 132 read with section 25 of the Karnataka Land Revenue Act, subjected land therein were converted land. This court further taking into consideration the other proceedings in regard to subjected land before legal forum, since the converted lands are out of domain of the proceedings conducted under section 130.
Now,
This is
no, correct. Now, annexure L is given a finding in the operative portion that it is a private land and has rejected the contention of government land. No, once a finding, correct, but how many times, no, civil court has decided, DC has decided. It's simply abuse of process. Now, the state is a party in before the civil court. Finding is recorded that it's a declaratory suit. That suit has attained finality. Once it has attained finality, on the revenue side, you can't reopen it. It's simply a waste of time. That's it.
waste of time and
Nothing is there in this. What is there? Now, civil suit has attained a finality. Now, that kata number is there in the schedule. Anything other than I'll dictate it before releasing, if there's anything you point. Prima facie, there appears to be nothing in this. Now, there's no point in asking them to go to the DC. Civil court has already recorded a finding. Just show me the schedule of the suit.
our land.
schedule of this old number 7/1A, 7/1B, 7/T.
That is not their case at all. Code.
Let us just have a look at the sheet.
I'll definitely tell you. So this is the same, but ultimately the order of the land tribunal granted by the land tribunal. Same order is under question. I am not asking any other land. No other lands are available. Other lands are totally different land. That is nothing to do with our only the. But I have not produced land tribunal order. I thought it is not required. So lot of people are saying the document also is here.
So the schedule is at page 184. Suit 716.
Before that, I will take you back.
The government
This survey number will range this
7/5.
ಆಮೇಲೆ ನಂಬರ್ ರೀನಂಬರ್ ಆಗಿತ್ತು ಟೋಟಲಿ ಸರ್ವೆ ನಂಬರ್ 7. Please come to 180 degree copy making.
9 acres and 7
Yes,
acres.
yes,
7.
But land you will actually kindly see land bearing measuring 7 acres in survey number 7, new survey number 7 situated so on. This is the blood order. This is the one case. In another degree also will actually kindly 184. There are 2 persons. 180 is 1 person.
The
184 is another person.
7/5.
Yes, 7/5.
Is the subject matter of proceedings
Before the land tribunal order.
before the DC also.
This everyone, but even the land tribunal order may kindly be seen on this the form 10. We see this. I have a certified copy because the trial court record. But if you actually want to see this matter, you will have to see this. It is the order dated. This order, form number 10 is dated 10th May 1982 order.
What I want to know that the 7/5.
5 and 6, but we are concerned about 7/5. Yeah, 7 order is here only.
Whether it is that same 7/5 is also part of proceedings before this DC.
Yes. But even the suit also, the suit and DC also. Please come to page 102. And we are the parties, that is, there is no about this. Against us only. Please see the Karnataka state magic.
Yes.
The place, council to respondent number page. May request you also to come to original suit, but all records are available. Page 1, please come to page 114. 114. Deputy Commissioner order alli inde eneno barutte. Please come to page 114, para 3. Page 114, para 3. Let me kindly come to page 114. Seven 7/5 ಆಗಿದೆ ಇದರಲ್ಲಿ there is a reference also the civil court order statement.
What then? So what I want to know,
Whatever the bird, I am not concerned about other land. I am concerned about only 9 acres, 2 persons.
7/5.
7/5, yes.
No, correct, sir.
My
Only-
word, there are two things, sir. This is order also. Very, very clear. Order number 10 is here. And tribunal order, and form number 10 is also there next. This is land tribunal order. Then please come to next page, form 10. Indonesia. Form 10. Other 11 is the next scheduler. And the same was become 7/5. And the exhibits.
Next year L. Page some difference is there. No, now all these sub numbers are a part of original survey number 7, measuring 39 acres, 18 guntas. If you get it at para, at the second page of that order, same order of the Assistant Commissioner, at third paragraph, the Deputy Commissioner in case so and so has held that land in survey number 7, measuring 39 acres, 18 guntas. So if a portion of that survey number 7 is held to be private land, all sub numbers of the land which form a part of 39 acres are to be held to be private lands only. Page 200. That, so the entirety of 30 survey number 7 of 30 39 acres is recorded a finding that it is private land in the previous order. Correct. So what holds good for other sub numbers of 7 must hold good for 7/5 also. Because all is a part of the larger extent of 39 acres in survey number 7. Correct. Now the PIL is also filed.
The report,
Ah.
he has very clearly mentioned, he has inspected, went to the spot. Detailed report was filed, and ultimately he says
Where is that report?
that is like page 82 annexes C.
No, what I'm saying, forget about these orders of the revenue authority. If 7/5 suit is decreed and you have suffered a decree and that has attained a finality, suit for declaration, then interfering in challenge.
But even the principles of res judicata is applicable as against them. They can't do it.
You only say that OS so and so was decreed, finding a state has suffered a decree, and that's a suit for declaration. That having attained finality, question of directly or indirectly reopening proceedings on the revenue side does not arise.
With respect to the plain scheduled property also, the lordship can, if they have any government land, let them take it. You have no.
Where is the COD report?
92, page 92.
Page?
Page 92. Section G, page 92. Detailed report, but he has referred all these documents, revenue proceedings, LRF proceedings. Ultimately, conclusion may kindly be seen. Page 100. Page 100 for conclusion. All these documents, everything has been referred. Page 100. In conclusion, that should clarify.
Oh.
In conclusion, it can be said that at the land bearing survey number 7 of was a private person solely land given by Act 1950 and all along. LRF orders and but that is granted. And C. B. Nagaraj, Srinivasa, Iyengar, etc. and others revenue officials have fabricated the revenue record and allowed themselves to be influenced by outside forces, and the petitioner's allegations against the revenue inspectors, accountant and others are possible. As per that allegation, it is not correct. But as far as these authorities are concerned, they have made all these things only to harass us.
Only say that the suit has attained finality. Question of reopening proceedings on the revenue side, give whether under 136(3) or 67 will not arise. Now, suit for declaration, it's not only for injunction. State is a party and you have suffered a decree. They refer there to the land reforms order. The
This is the
2:30 I'll start. I'll dictate at 2:30. 2:30. No, that 7/5 is not referred to in those DC orders. So we'll just
7 by what? 7 is a larger extent. 35 acres and all that. And 1, 2, 3, 4, several other tenants were also there. They are not parties. I will not know. For them, they have left it out because Western Commissioner, he has left them out. And in one first order, he has mentioned 7/4. Next order, only 7/4. But it's all from the beginning, you can see anyway, all records are available. And trial court, but ultimately the civil court has gone into all these documents. Revenue record, 1920, the inquiry has been held. From then we are in possession of the property. All of a sudden, in PDO comes in 1991 and says that we are farming Ashraya layout. Their problem started because of the local politicians. Some they wanted to farm layout in our property. We oppose. That is how it has started.
that finding on that issue number 4 deals with
Against
the
them.
LRF orders. have a look at it. We'll record that and get over it. Oh. Request.
Definitely after 2 weeks.
Request on behalf of the petitioner who intends to file a rejoinder. List the matter on 5th. Hmm. 9th. Extended till the next week. court has referred to the COD report. Here we are not challenging. Though reports of the tribunal have not been placed before the court, COD report records a finding that its Form 7 is there in the register and it cannot be stated that it's a bogus order. Once the civil court records a finding, there ends the matter, directly or indirectly, that cannot be reopened in the revenue case. That is that I'll observe, that I'll say, but I'm saying, finally, the full bench in Jayama's case has also said that revenue courts cannot enter into titles. The petition was sought for setting aside the order of election in passed by the assistant commissioner, whereby assistant commissioner has observed that Mutation, Bangalore South is directed to file proceedings under 67 subclass 2 of the Karnataka Land Revenue Act to claim title of the government lands and take steps for maintenance of revenue records in the name of the government. The order at annexure M passed by the Assistant Commissioner on 3rd August 2016 in case number NND RA within bracket S 08/2016-17 relates to proceedings upon a complaint of P.J. Abraham that the land in old survey number 7 within bracket new number 7/1 capital A, comma 7/1 B, comma 7/2, comma 7/3, comma 7/4, 7/5 and 7/6 situated at Doddabele village, Hingeri Hobli, Bangalore South Taluk, was originally a government land, and certain individuals have concocted documents and obtained orders from courts, and accordingly complainant has sought for proper steps to protect government land and to maintain revenue records in the name of government. In terms of the said order, is a clear finding that petitioners herein were not served notice separately, but note is taken of service of notice in RA within bracket S 283/2015-16 in respect of same subject of land. And accordingly, notice in earlier proceedings is taken to be sufficient for the proceedings, present proceedings before the AC impugned hearing. Though the distinct commission takes note of the order in RA within bracket S 283/2015-16, which was disposed of by an order dated 28th July 2016. AC, however, directs for an inquiry and appropriate proceedings under section 67(2) of the Karnataka Land Revenue Act in order to protect interests of government and to ensure maintenance of records in the name of the government. Though various contentions have been raised, however, no senior counsel appearing for the petitioner places strong reliance on the judgment of the civil court in OS 715 of 96, called with 716 of 96. Which is a suit filed by the petitioners hearing the petitioner number 1 was the first plaintiff, and petitioner number 2 was the second plaintiff. Who is this Channappa? No, the cause title.
Petitioner
Now the
1 and 2 are the son of Narasimhaya. Petitioner number 3 is the son of Channappa. There are two applications. Third petitioner may kindly be. Third petitioner is Narasimhaya, son of late Channappa, died. That's why he is son. And these two petitioners are son of Narasimhaya. They are the original grantees.
page 111, cause title of the suit.
Channappa
Is the first.
is the father of Narasimhaya.
Ali plaintiff number hakila.
Number.
He is the plaintiff in the other suit.
The OS 750, there are two suits. One carried by the two suits.
in OS 716 of 96, while the third petitioner, Narsimurthy, is the son of the plaintiff Chennappa, isn't it?
OS has
In-
been of 90.
In OS 715 of 96. It is submitted that the original suits were, that is OS 716 of 96 and 715 of 96, the suits were declaration to declare the plaintiffs as an absolute owners of scheduled property, in which the state authorities, that is the state of Karnataka, Tahsildar Bangalore South Taluk, and the block development officer, Bangalore South Taluk, were arrayed as defendants. He submitted that after a full trial, suit came to be decreed in favor of the plaintiff with a specific finding in the affirmative regarding title of the plaintiffs, and also finding in the negative as regards the assertion of the state to be the absolute owner of the property. It is submitted that in light of finding before the civil court having attained a finality, in which the state were parties, question of attempting to reopen the correctness of findings by the civil court by recourse to revenue proceedings does not arise. Reliance is placed on the judgment of the full bench of this court in the case of Jayamma versus so and so. It is submitted that without entering further into the various other orders passed by the revenue authorities, taking note of the judgment in OS 715 judicial process. He submitted that the question of remanding the matter back to the petitioner to avail of remedy to challenge the validity of the order of the assistant commissioner before the deputy commissioner is an exercise in futility, and that contention of the state on such ground requires to be rejected outright, and the continuance of wholly vexatious proceedings ought to be put an end to by setting aside the order of the assistant commissioner. Then HCGP appearing for the state would submit that the order at Annexure M could be challenged by way of revision before the deputy commissioner, and this court ought not to entertain the present petition.
Order passed by the assistant commissioner is under no provision. Therefore, I cannot go to any other place. Land revenue actually have provision. There is no provision under the land revenue.
And it's further contended by the HCGP that the findings in the suit are based on the orders of the deputy commissioner, which do not pertain to 7/5, and accordingly, reliance placed by the court on the order of the revenue authority are without any basis. It's contended that 7/5 still contains, still remains government land. Next, heard both sides. Though voluminous records have been produced by the petitioners. The point for consideration is as to whether, in light of the findings in OS 715 of 96, called with 716 of 96, the order at Annexure M of the Assistant Commissioner is permissible in law. That's the only question. We need not enter into.
Even under earlier revenue proceedings also. So this,
No, correct. What I'm saying is that once the civil court has recorded a finding, the rest of it pales into significance.
correct. You taken by your logic in another matter.
So we'll just shorten it and conclude.
Matter.
The-
Once this report gives the decision, there is the matter.
it must
And even
be-
otherwise in 136 proceedings also, they held in our favor. Deputy Commissioner.
It must be noticed that though the land HCGP has contended that the order of the Assistant Commissioner at Annexure L in RAS 283 of 15-16 does not have a reference with respect to survey number 7/5. It is to be noticed that the civil court in a comprehensive suit in OS 715 of 96 and 716 of 96 has upheld the title of the plaintiffs who are the petitioners herein while negativing the assertion of title by the state. The issue is framed in OS 715 of 96 and 716 of 96 are as follows. And the findings, the page 119 and page 120. Findings by the civil court as regards such of the issues is as follows. Page 123. The civil court has recorded a detailed finding with respect to issue 1, 2, and 4 in OS 715 of 96 and 1, 2, 3 in OS 716 of 96. The said issues relate to title in the plaintiffs as claimed through orders of the land tribunal, as well as title set up by the state as being the owner of the property. The civil court, after the detailed finding, has recorded an affirmative finding regarding title in the plaintiffs. The civil court has referred to orders passed in LRF 2382 of 76 and 2383 of 76. The court has also referred to the report of the COD at Exhibit P26, which was an inquiry on the basis of complaint. And such report was submitted to the government by the COD. The civil court has extracted portions of the report of the COD and has held that the orders of the land tribunal are not open for doubt and cannot be set, and the form number 10 cannot be said to have been fabricated as contended. Insofar as the specific stand by the government that sites were formed, Ashraya sites were formed, the court has recorded that no material is placed to substantiate such stand and has disbelieved the stand of the government on such assertion. The judgment in OS 715 of 96 and 716 of 96 has attained finality and has not been challenged by the state. Though learned XCGP were to point out that the reference by the civil court to the proceedings before the revenue authorities may not be correctly construed as a revenue authority in the order of the assistant commissioner in RAS 283 of 1516 does not refer to Channel Bar 5. However, the said aspect by itself cannot be sufficient to assail the order of the civil court. Next, it is a settled position of law that the jurisdiction of the revenue authority is limited. The inquiry by the revenue authorities is also a summary inquiry and cannot go into aspects of title, adjudication of which is within the sole domain of the civil court and does not stand excluded by the procedure provided for inquiry and adjudication regarding revenue entries under the scheme of the Karnataka Land Revenue Act. The question of title, once is recorded after adjudication by the civil court, the same would be conclusive and binding upon the state and its entities. Such findings made in exercise of exclusive domain by the civil courts cannot be tinkered with directly or indirectly in the guise of revenue proceedings, as is sought to be done at Annexure M. No doubt there may be alternative remedy available as regards to the order at Annexure M. However, it is a settled position of law that the power of the court under Article 226 and 227 is wide enough to entertain a writ petition where grounds are made out. In the present case, the order at Annexure M is clearly an abuse of quasi-judicial power. Under what provision of law the complaint is taken note of and the order passed at Annexure M is not forthcoming from the order. Even otherwise, once a state has suffered a decree in OS 715 of 96 and 716 of 96, the order at Annexure M could not have been passed. The Assistant Commissioner does not make a whisper regarding the outcome of the suit in the impugned order. And accordingly, it can be stated that the order at Annexure M is on the basis of a wrong premise without taking note of the conclusive finding rendered by the civil court regarding title of the plaintiff while negating title of the state. Accordingly, the order at Annexure M requires to be set aside in light of the findings before the civil court in OS 715 and 716 Full stop. The title having been affirmed by the civil court, question of reopening the proceedings, indirectly asserting that it is government property once again does not stand to any legal scrutiny, nor are any grounds made out for such stand as is sought to be made out at annexure M. Further, it would not be out of place to notice that the proceedings under 136(3) initiated in RRT to CR 100-93-94 relating to that is enough, because that also doesn't mention 7/5. That would suffice.
Even this honorable court, well, they have challenged the order of the deputy commissioner, made it very clear that your order, whatever the order, is subject to the result of the criminal suit. That in the annexure F, page 86.
It must also be noticed
Clear for that. Page 86.
that in earlier proceedings between the petitioner and the state in WP 50760 of 2004, the court, while considering an attack to the order in revision petition 88 of 2000-2001, while upholding the order of the special deputy commissioner, had made it clear that the said order will be subject to the result of OS 715 of 96 and 716 of 96, pending before the Civil Judge Senior Division, Bangalore Rural District. In light of such finding, the order of the revenue authorities was eventually made subject to the outcome of the suit, and the suit having been decided, there ends the matter, and question of any further proceedings by the revenue authorities would not arise. Accordingly, petition is disposed of.
That petitioner 1 and 2, they were also having a sister. They filed an application R1 to send to BCC to come as a petitioner. They have no objection because they are sisters, female members. Now they want to come on record, we don't mind they are coming.
We are 1 of 23. Has been filed.
There are 2 years.
Huh?
There are 2 ways.
Which is the other I? Which is the other IA? What is the IA number? IA 1 of 23.
Want to come as a petitioner.
IA 2 of 23 have been filed by the sisters of the plaintiffs, petitioners, claiming that they have an interest in the property. It's order sheet only. Order sheet only. And in light of the admitted relationship, both the applications are allowed. Necessary amendment to be carried out to the. Huh?
ಮಾಡಿದ್ದಾರೆ
So now the cause title. First petitioners and people. The petitioner number 4 and 5 who have been imputed subsequently are the sisters of petitioners
1 and 2 and 3.
1, 2, and 3. First, one sentence allowed. So that is the starting point for partition 3.
Allah have said, suppose we oppose, they will become respondent. Again, we have to face one more problem with the government. So then I said, there is no problem, let them come. Whatever here they have to give it. That's what I said. Ultimately, sisters are also entire father's property. Bring that paper.
Now,
Okay.
very good. No. Is it clear enough? We can take up the matter, or you want some time? Huh?
Either pass an order, all of a sudden,
No,
going
no,
against-
if both of you are going to be ready, I'll take it up. I don't want to do it piecemeal.
I am ready, Lords.
We'll have it on Tuesday then. Get ready. At one go, once we start, we have to finish. There's no point in it. Tuesday. Wednesday. Wednesday. Relist the matter on Wednesday in the same stage. Yes.
Double. Good. Petitioner for this. See, okay.
Today.
Land, much lots and the rehabilitation plot. 4.25 acres of land were planted in 1857. Subsequent ingot to the year 2010 million, alleging certain violations of the grant was cancelled. Against which I prepared an appeal under section 49 for the KAT, which came to be allowed. And in the present petition, I sought to implement the orders of the KAT and record the revenue entries in my name, the name of the petitioners.
Land in which survey number?
This is land in survey number
Same, 17.
same number. Even the order of the KAT includes 32234 of 2019, the matter which is being disposed was filed by Mr. Ramappa, was late of Sadia Nayak Milords. Milords should kindly come to page 11 of my petition, Milords. This is the order of the appeal, Milords, passed by the KAT.
What happened before the KAT?
The order passed by the regional commissioner was set aside, cancelling the grant. And I have sought to implement this order.
So that is stated to be forest land.
Now they have come up before this court, they take up the stand that it is a forest land now, not even before the KAT. Lands were granted in the year 1957.
Same direct. Just have a look at it. Now you have taken the stand in that matter that this land which has been restored is forest land. So same survey number, present order. So it is the
Submission made. Only requirement is best lot. But all the street consider not to fix any alienation period. But not say that now they are granting it upfront. And again, the non-alienation period.
you want to sell it, retain the land.
In case,
More than that.
at least the date of the earlier grant may be taken into consideration.
That is why you want to sell the land. Our first allotment ಕೊಡ್ಲಿ. ಇನ್ನು ಕಂಟೆಂಪ್ಟ್ ಎಲ್ಲ ಬಾಕಿ ಇದೆ. ಸುಲಭವಾಗಿ ಸಿಗಲ್ಲ. The petition, present petition has been filed. Seeking for writ in the nature of mandamus to direct respondents to consider representation at annexure B to D to implement the order dated 10/2/2017 passed by the Karnataka Appellate Tribunal. Next, the order at annexure A is an order whereby appeal before the Karnataka Appellate Tribunal filed by the husband of the second petitioner and son of the son of Annamma came to be allowed, setting aside the order dated 26/3/2010 in LND CR 159/2008-09 and consequently cancellation and forfeiture of lands granted in survey number 17 of Shiranahalli village, Tirthalli Taluk, Shimoga district was set aside and ordered to be restored. It is noticed that insofar as an identical factual matrix wherein order of the appellate tribunal in 981 of 2011 as regards some of the, at the instance of some of the other landowners.
The very same petitioners, others,
Correct. There are four claimants.
yes, sir, only one.
Some of the in the bill, some of the other. As regards some of the other co-owners. Was sought to be implemented by way of direction sought for in WP 32234 of 2019 has been disposed of in terms of the following observation. Repeat para 2 to end. In light of the present petition also seeking for identical relief relating to the same order of the case. The present petition requires to be disposed of, taking note of the observation made in WP 32234 of 2019, extracted as above. Accordingly, respondents 325 are directed to comply with the order of the KAT in Appeal 981 of 2011, or in the alternative, allot land measuring
4 acre 23.
same
All 4 of them were allotted to 3 acre.
each 4 acre 25 guntas in and around Shiranahalli village, Tirthalli Taluk, within 6 months from the date of receipt of certified copy of the order. Now all the 3 are entitled for
4 acre 25 gunta.
each. May 4 acres. .2 4.25 in each of the petitions.
Instead of co-owners, clearly place grantees. They are not co-owners. Lots made a
Similarly placed grantees.
grantee.
Yes.
Pertains to an obstinate refusal to grant, conduct 4D and grant different survey numbers. Give them my lot of background. So the land in question is survey number 65, village called Alage Voderahalli village.
No, now your application is still pending.
My application is of 2014.
Still pending.
But there is I'll point out what has happened in between. Now, may kindly give me a few. Not in 1974, this extent of land, survey number 65, consists of 11 acres and 30 guntas.
Statement of objections are filed.
11 acres and 30 guntas. Not in that, on 4/3/1974, 4 acres of land was allotted to one Sri Rangaswamy, to whom the petitioners claimed. That's on 4/3/1974. Then on 6/7/1974, 2 acres was granted to one lady called Puttamma.
The same survey number.
In the same survey, I'm only talking about that. On 23/7/74, 3 acres was granted to one Papaya. And all of these grants are under the Inams Abolition Act, because it was admittedly an Inam village taken over, and these grants were under Section 5 of the Inam Abolition Act. A premium was also paid in furtherance to the grant. Now, that would leave us with,
basically re-grants.
yes, yes. And kindly see under on 28/1/2006, the 2 acres and 30 guntas was left behind. On 28/1/2006, the government in a public auction sells this land to some Umrah developers and associates, some Yusuf Sharif.
A series of disputes are there regarding this.
There's no series of dispute. Kindly see, this is in 2006, the government itself sells a portion of land in a public auction for a developer. Now, in all of these things, after this 1974, it looks at page number 25 and an extra 8. Will get the order of grant in our favor.
Yes.
The operative portion is at page 26. Now,
GK Rangaswamy.
GK Rangan. Now, there's an endorsement which we will find at page 29, which is calling upon us to pay premium, etc. Then, my lord, at page 31, my lord, will get the order sheet relating to this proceeding, all of which to show that this land was part of a grant towards 1970. Then, my lord, in annexure B, my lord, will see mutation extracts where the names of GK Ramaswamy is included in the RTC pursuant to this grant. It was done only in 1984-85. There was some delay in getting that done. It was done in 1974-75. Annexure B at page 25. The first item, not clear, but there's a typed copy at page 36. 36. 35 is page 36 is typed copy.
Yes. This is the mutation.
It's a mutation.
Yes.
Now, my lord, in 2012, my lord, an RRT proceeding was initiated, contending that this grant itself is bogus, that they can't find records of it. Kindly see, the RRT proceeding order is at page 38, starts at page 38. Now, at page, if my lord goes to page 39, and my lord see in that, on page 38, my lord see, GK Rangaswamy is the first respondent. Puttamma, Papaya are the other respondents.
It's under 136.3.
Under 136. At page 39, my lord may kindly see. These are proceedings initiated under 136.3 of the Karnataka Land Revenue Act to find out the genuineness or otherwise of entries reflected in the revenue record in respect of land and survey number 65 and 124, Halge Vaderahalli, Kengeri Hogli, Bangalore South Taluk. So, proceeding initiated to find out the genuineness or otherwise of the grant in our favor.
Actually, only revenue entry. You look at 136.3. It's only with respect to
the revenue entry.
Orders under 127 or 129.
Under the Land Revenue Act. But anyway, this proceeding was initiated. And now, the contentions of various parties are there. Then, last paragraph there talks about GK Rangaswamy's contention, how he's been in possession for so long, he's held on, and so on and so forth. All these are various contentions are noted. Then, kindly see, order starts at page 40.
It's dropped, is it?
No, yes, the proceeding, he came to the conclusion that this is genuine, and they have been in continuous possession. This is all, these records have been related to various, and there is no basis for contending that that the grant in their favor is bogus or otherwise. And these various contentions that were advanced were taken up way back on 7/12. This order is of 7/11/2012.
So there should have ended the matter.
Matter should have ended there. Of course, in this what happened, my lord, was the one lady, that Puttamma, did not represent herself. So the order did not inure to her benefit, but she filed a writ petition subsequently and got a similar order in her favor. I am not concerned with that because that's a different owner. Now, my lord, then kindly see what happens after this order. My lord, Rangaswamy passes away. His legal heirs are also brought on record. That document is at annexure E. That mutation is registered is relating to that annexure E. Then that is in 2013. I'm giving my lord in sequence of time. So that was in 2013. In 2014, my lord, we make this application for OD Duras, and that application is at page 50, annexure F.
Annexure E.
Annexure F, my lord. Application is annexure F.
Annexure E.
Annexure E is MR, my lord.
So it's transferred.
Transferred in the name of the present. Then
that is to the wife and the children of Rangaswamy. Yes.
Then, my lord, annexure F, my lord, is our application for OD Duras on 28/5/2014. Now, my lord, after this was followed by a report of a revenue inspector, which may not get at page 4. And the Taluk surveyor also prepared a sketch showing the area that we are in possession of, etc., which is at page 58. All this was as far as our pursuant to our application for OD.
Then, my lord, kindly see what happens is an order comes to be passed stating that now may I request my lord to kindly go to annexure M at page 79.
On page,
79.
slight difference.
I'm sorry, my lord.
Annexure
My lord, it is annexure M.
M.
Writ petition annexure M, page 79 and sorry. 79.
It is the writ petition.
Writ petition.
Yes.
Order of 30th of September 2020. Now, can I request my lord to kindly go to the bottom part of page 80, where my lord, what I have just mentioned is narrated.
Internal page.
Page 80, my lord. The next page, second page, internal page. Petitioner's father, T.K. Rangaswamy, was granted 4 acres in survey number 65 so under section 5 of the Karnataka Enacted Policy Act. Likewise, land measuring 2 acres was granted in favor of Puttamma on 6774. Land measuring 3 acres was granted in favor of Papaya. The total extent of land in survey number 65 is 7 acres and 30 guntas, out of which the land measuring 9 acres was granted in favor of the person. Thereafter, the names of persons was affected in the revenue record. On the basis of some allegations, an inquiry was conducted with regard to genuineness of entries made in the revenue records in respect to land bearing number 5. After holding an inquiry held that the entries made in the revenue records in respect to the land in question, the name of the petitioners, father and Papaya, were held genuine, and it was further ordered to restore the kata of land in measuring 4 acres in survey number 65 in the name of the petitioner's father. However, respondent number 1 cancelled the entry standing in the name of Srimati Puttamma, one of the so and it was further directed to resume the land granted in favor of Puttamma. Being agreed, Puttamma filed writ petition. This is the other part. The court, by order dated so and so, directed respondent number 1 to consider veracity of endorsement, which depicts that there is an order to enter her name in Puttamma as per section 5 of the land revenue. Thereafter, respondent number 1 by order dated so and so, 28/4/2014, directed respondent number 2 to restore the name of Puttamma in all the relevant revenue records and ordered for dropping proceedings against Puttamma also. Then, respondent number 1 again initiated proceedings under section 136 of the Karnataka Land Reforms Act so as to inquire with regard to the genuineness of grant made under section 65. So, second proceeding stating that respondent number 1, after issuing notice and hearing, cancelled the grant made in favor of the deceased father of the petitioner on the ground that the land is uncultivable and that there is no direction to enter the register the name of T.K. Rangaswamy as an occupant. And also there is a difference in the signature of T.K. Rangaswamy and the grant made in favor of T.K. Rangaswamy is not genuine. So, not kindly see. These are the various grounds on which this order, being aggrieved, this writ petition is filed. So, this writ petition was against that order under 136. But proceedings where land is not cultivable, that the signatures don't match, that this grant made in favor of so and so is not genuine. So that order was challenged in this writ petition. Third counsel for the petitioner submits that the validity of grant and entry made in the revenue records have been inquired by respondent and by order dated 7/11/2012 was held the entry made in favor of T.K. Rangaswamy.
Now, this was set aside.
This was set, and on all counts, this was set aside. And if my order now looks at the operative portion of the order, the order was set aside. They were directed to certify 4D durasti work already approved by the competent authorities and issue order in favor of. So when my application for 4D came up, all these issues started. And that, my lord, we thought was culminated with this particular writ petition. Then, my lord, we then approached them saying, please grant us the 4D, etc. My lord, a contempt was also filed. I didn't point out that I'm sorry for this. I realize it's not part of me. I violated a memo. Meanwhile, not behind me. We just share one. This is a compliance affidavit that is filed by the Tahsildar. The same Tahsildar files the objections in these proceedings. The Tahsildar then says, I have approved the 4D and jurors as per directions of the court in para 2. I've complied with with the order. This is the delay, he says in para 3, is because of pandemic and so on and so forth. And then, now kindly see, he says that the proceeding initiated under 67 is presently so and so. However, he says that I have done everything, that this is in the process, it will get done. This contempt is accordingly closed. Now, my lord, this pursuant to this order, but the Tahsildar, the endorsement that he talks about, the endorsement that we will get at page 89.
Sure.
I'm sorry, my lord.
Yes,
So what's the page number in my lord? I'll know the
100.
100. 11 pages. My lord, it same.
What was,
Correct.
what was the endorsement?
The endorsement effectively said a few things. One, as per the writ petition order, the SPODI, etc. has been taken up. Forms and documents have been sent to the Assistant Commissioner and Assistant Director of Land Records. Then he says there is an issue of genuineness of grant and it's rocky land as per village map. So some inquiry about genuineness, one more report is called for. Then Assistant Commissioner has forwarded the file to Assistant Director for next steps for making of the 4D. Then he also refers to the 67-2 proceedings in this endorsement of 5.3. But one of this endorsement of 5.3 is withdrawn and a fresh endorsement is given on 16.3, which is at it may be 111, 112 of my lord's paper.
102.
102. That's at page 16.3. They are identical except for the fact that this reference to 67 is no longer there in the second one. But my lord, what happens is they had initiated one more proceeding under 136B. Same contentions. And my lord, now I have, along with the memo, my lord, kindly see, it was filed with a memo on 11/9. That proceeding also was has the my lord, come to an end with the Special Deputy Commissioner saying this can't be raised again and again. The same thing I have already decided. There's no material to show anything is not genuine. So this is ordered on 10th of November 22. Oh, I'm okay. We filed these with the memo. I'm sorry.
No, but now what's happening?
Now, my lord, kindly look at the objection. The same Tahsildar files that compliance report before in contempt proceedings, stating that this is being done, it will all get done. Now, please look at it. In the state. No, the relief sought for in para 1, he says this is what the relief sought for, but the relief sought for cannot be granted for the following reason. Can you see para 2, my lord?
No, what is your objection?
His objection is it is rocky land. It is not genuine.
No, but now, correct. But now, after a 136(3) proceeding on 3 occasions have been dropped, you can't go back on the validity of the grant. What is only sought for is 4D.
And my lord, there is no kharab as per revenue records. Neither A kharab nor B kharab. Entire 11 acres and 30 guntas, as per their own revenue record, there is no kharab.
136(3) proceedings are dropped, and the revenue entries in favor of the petitioner and upheld. 4D proceedings cannot be stopped on any other pretext, including its rocky, cultivable, because the grant remains undisturbed.
And my lord, can I just add to that, my lord? Kindly also note this, on 28/1/2006, they auctioned 2 acres and 30 guntas of the same survey number and give it to a third person. And now they're saying, no, I will not do a 4D of this survey.
Just read the relevant paragraph of the yes.
In para 1, they say what they try to summarize what our writ petition is in whatever manner, but they say it is petitioners are not entitled for the relief for the following reasons. In para 2, it is pertinent to mention that the entire relief sought for the petitioner is based on the order of 39/2020 passed by this honorable court in writ petition number 7. The petitioner stating that the subject matter is only with respect to reflective revenue entries based upon the completed OD and juristry work, which is pending on the file of the respondent number 4, Tahsildar, past 7 years. However, revenue entries will not be carried out with, now kindly mark these words, revenue entries will not be carried out with Tahsildar unless your new survey number has been given by the Assistant Director of Land Records, the authority. In the present case, the land in question is a hill rock, uncultivable and unfit for agricultural purpose, where it was proved that the land in question is an uncultivable land. There is a difference in signature of the part of the petitioner in whom the land was granted and is not genuine. And under the guise of the writ petition, relief is being sought, wrongly obtained for the same contention considered in the previous writ petition. However, to meet the grounds urged in the instant writ petition, also substantiating the stand taken by the state authorities, submitted the survey number 65 also is basically a hill rock as mentioned in original timpani and also an index of land in survey number 65. Then, in paragraph 4, he says it is Kharab land. Kindly see, it is submitted that as for records maintained the Department of Survey, Settlement and Land Records, the land in survey number so to an extent of 11 acres and 30 guntas is basically a Kharab land. Not revenue, the RTCs, there is not a single, not a gram of Kharab land in any of this. Neither, and if it is 11 acres and 30 guntas, they ought to answer how 2 acres 50 guntas came to be subject matter of an auction by them in favor of a third person.
Akar Band is produced.
It was produced in the previous round of repetitions. Can you see annexure H?
Diction.
H. It's a sketch that was prepared. Along with the compliance report, also, they had produced a sketch. And even in that, Malad kindly see, Kharab 0.
Because you filed contempt, is it? Objection. It's wrong. 3 times 136.3. Every time you go and say complete 40, 136.
Same. I am reverted back to the same. And it's only for the 40. They have no, it's not as if they have taken any other proceedings. Only if I ask for 40. Close.
You complete it within 3 months. There's no defense. So suppose 136.3 months, 3 times it's closed. There ends the matter. It's not a milking cow or milking pig or cow. Huh? Every time you go there, one proceeding. Come tomorrow, we'll close. Close. Huh?
No, I have not been part of the
The
and I hope there will be none after this. In that streak of luck somewhere.
contempt, I think, has some trigger. I don't know. The petitioner.
Completed the mapping, the demarcation, everything is done. They just have to allot new survey numbers. The subdivided new survey numbers to be allotted and revenue records have to be entered. That alone is being kept pending.
The petitioner was sought for issuance of writ of mandamus. Direct Respondent number 3, Assistant Commissioner to approve OD and Durasti work completed and approved in terms of annexure N and P. Petitioner also sought for a direction respondent 6 and 7 to forward Form 10 as per GO dated 25/1/2010 to the office of the Tehsildar R4. Petitioner has also sought for appropriate direction to respondent flow to change the revenue records by assigning separate independent survey number to the land measuring 4 acres belonging to the petitioners after completing the OD and Durust proceedings. It is to be noticed that admittedly the admitted facts being that the petitioner's first petitioner's father and the husband of the first and third petitioner's father, first, third, and fourth petitioner's father, and husband of the second petitioner was a recipient of re-grant under section 4 of the 5 of the Karnataka Personal and Miscellaneous Norms Abolition Act 1954 with respect to an extent of 4 acres in survey number 65 of Alge Vadirandi village, Hingeri Open. By order dated 4/3/1974. It is further submitted that mutation entries were effected in the name of Rangaswamy as per MR number
24 of 84/85.
84/84-85/987 as is evidenced from the entry at annexure
Yes, basically. D1.
annexure B. It is submitted that on multiple occasions, proceedings under 136(3) were initiated and came to be dropped, namely in RRTCR 357 within bracket capital /9596 with a order dated 7/11/2012, comma, next one.
Then my lord, application was filed for 4 days notice on 28th.
No, the second,
Second is after the application. That the second proceeding, we produced the order of
this one.
in the writ petition, not that one, in
Not at page, in my lord, page 79, that is page 90 of it. Next year,
This is the second time.
this is the second time. This is that order was challenged in this meeting and set aside in this meeting by the.
Now this annexure C upheld, is it?
This is upheld because that's in our favor.
Correct. So then which is the next one?
No, the next one is the order itself is not produced because the High Court order is. The High Court order is the next day.
So the second time you challenged it. So they set
Second
aside.
time they held against us, we challenged it, that was set aside.
Babu. ಅದು A ಅಂತಂದ್ರೆ. B. Once again, proceedings were initiated under 136(3) as per the and order dated 4/6/2019 came to be passed, setting aside entries in favor of the petitioner, which came to be challenged in WP 31896 of 2019, which set aside the order passed under 136(3) with a further direction that the Tahsildar was directed to certify the OD/Durasti work already approved by the competent authority and to issue an order in favor of the petitioners. Idu B antame. Comment C. He submitted that once again on similar grounds, proceedings were initiated under section 67(2) read with 136(3) of the KLR Act in RRT 2 within bracket S CR-7 capital A /2016-17, which came to be disposed of as per order dated 10th November 22. Dropping the proceedings under 136(3) as well as 67 clause 2. Next. The Lord Senior Counsel, Sri Arun, appearing for the petitioners, admits that finally endorsement at annexure P has been issued. To the effect that proceedings are in progress and subject to final outcome of proceeding before the Special Deputy Commissioner. Proceedings would be progressed. However, it is submitted that till date, no proceedings have culminated so as to complete the 4D and Durst proceedings. Attention is drawn to annexure N, is it?
Yes. Next end. Page 9, page 100.
To annexure N. which was the earlier endorsement.
First page, last paragraph. Last line. Where he refers to 67 proceeding. ಪ್ರಕರಣ ದಾಖಲಾಗಿದ್ದು ಬಾಕಿ ಇರುತ್ತದೆ.
No, I'm saying the endorsement. What I'm saying is you refer to that sketch.
The sketch is at page 93, 96, 104.
Reference is made.
The sketch. But there are the.
So that sketch which demarcates all.
That my lord will kindly see at annexure H at page 58.
This also.
This also. This
Page
is
104.
this is the second one that they filed in the contempt proceeding, which is now at it is also my lord available at page.
Reference is made.
93 or 104. My lord.
Reference is made to the sketch produced at annexure at page 104, demarcating the land of the petitioner by way of a sketch, in which extent is shown as 4 acres and as regards extent under the heading Karab is shown as nil. Reliance is also placed on that recommendation, which is some recommendation was forwarded.
That is along with further
Annexure J. Annexure J.
Yes. J also. I have G, H, and J. All four.
Reference is also made to the report of the revenue inspector at annexure G. Comma, sketch at annexure H. And report of the Taluk surveyor at annexure J. It is submitted that despite all such documents, the impugned endorsement at annexure P has been issued, whereby it is observed that the land is Karab land consisting of rocks and hillock. And accordingly, matter is still under progress.
Not objection states he can't be granted. In his objection statement, he says it cannot be granted.
Next, accordingly, it is submitted that when the revenue entry does not contain any extent of land as Karab land, and said fact is affirmed by the sketch at page 104, wherein sketch has been drawn and the extent is mentioned as 4 acres, and under the heading Karab, there is a blank entry. The proceedings under 136(3) on multiple occasions having been dropped, 40 proceedings are to be concluded. Next. GA would submit that would submit relying on the statement of objections that land consists of hillock and rocks, and that OD proceedings cannot be completed. As the land is uncultivable and unfit for agricultural purpose, and that there are some discrepancies in the signature of the father of the petitioners.
Not it. Para 4 says entire 11 acre 30 guntas is Kharar. That is the stand in.
The contended that entire extent in survey number 65 of Halge Vaderalli village, measuring an extent of 11 acre 30 guntas, is Kharab land and consists of a hillock.
We have auctioned 2 acres 30 guntas out of this on 8/5/2005.
Next, heard both sides. At the outset, it must be noticed that 136(3) proceedings on three occasions have culminated in dropping of proceedings on 2 occasions and setting aside of proceedings by this court in WP number
318696 of 2019.
31896 of 2019 on one occasion.
I must mention that this order was challenged in writ appeal, and writ appeal was dismissed non-prosecuted.
As referred to in paragraph dash above. Once the inquiry relating to validity of entries of the petitioner have resulted in a finding that entries are proper, and the re-grant under the Inams Act remains undisturbed. The substantive rights of the petitioner stand upheld. What is sought for is only Podi and Duras proceedings. As is noticed from the records at annexure G2
GHJ,
G,
H and J.
H and J. One stage. The ground made out that the land consists of rocks, is uncultivable and consists of a hillock are totally extraneous reasons which cannot be put forward for completion of Podi and Duras proceedings. Podi and Durasta are incidents of enjoyment of title and ownership, and are procedural exercises that cannot be obstructed depending on the nature of the land. When the re-grant remains valid, as also 136(3) proceedings on multiple occasions have culminated in upholding the entries in favor of the petitioner. We find no valid or legal reason to withhold the 4D proceedings, and the endorsement, if read carefully, does not. They don't say that they will not do it. Only say that it consists of
Actually, in the objection statement, the first time they said we cannot do it.
the endorsement, if carefully perused. Only mentions that the area consists of rocky and uncultivable land, which by itself cannot be reasons to not complete the Podi and Durst procedures. There is absolutely no legal ground or impediment in completing the Podi and Durst is allowed. The respondent numbers 5 to 7. 5 to 7.
Response 5.
5 to 7 are to complete the Podi and Durst proceedings by taking it further to the reports at annexure G, H, and J, and complete the proceedings within a period of 3 months from date of receipt of certified copy of this order without raising any objection, any new objection in light of the discussion made up.
It will be 3 to 7.
Huh?
3 to 7. The special DC also has to one part of the approval has come from them. The allotment of the numbers, etc.
Upon completion of Podi and Durasti work, consequential revenue change in revenue entries to be made within a period of 1 month thereafter. You are totally unnecessary litigation. Completely unnecessary. And that statement of objections should not have been filed. Yes. Yes.
Times they have taken adjournment. Point is very simple. Earlier in 2007, division bench had directed that the auction purchaser must be heard by the DC. The issue was that there was a grantee for 1 acre 15 meters. That grant was held to be a bogus grant. So, and in the meantime, they auctioned about 3 acres of land to this petition, to this petitioner. But an issue came up as to whether the auction was not complete. In the meantime, the DC was going into the validity of the grant, as to whether it was a bogus grant or a valid grant.
You are the?
But I'm the auction purchaser's next purchase. I'm B.R. Srinivas. An auction was made sometime in the year 2009 of government land after it was notified. In the meantime, an earlier predecessor in title Narayan Swamy, claiming that he had a grant, he filed a writ. He said that his grant is prior to the auction. The DC said that these grants are fraudulent grants, and he started an inquiry. At that point of time, B.R. Srinivas was an auction purchaser, moved the writ petition before the Honorable Court and said, I must also be heard because I am auction purchaser. The single judge rejected, saying you are a 25% auction purchaser. You still not have paid the bill. It was challenged before the division bench. Division bench said that I am entitled to be heard in the proceedings before DC. That order not your lordship said at page number 52. This was an appeal by B.R. Srinivas, the auction purchaser. Can I read that? Top portion. The light of the power interpleading is allowed by setting aside the order dated 1/2/2011 past WP number watching connect. And directing third respondent authority to proceed with the inquiry in RRT numbers. And as directed by the court in earlier, same shall be completed within a period of 3 months from date of receipt of a copy of this order. After affording an opportunity.
Yes.
Within 3 months after affording an opportunity of to the appellate, yes. Not appellate is DR Srinivas was the auction purchase. In the meantime, what happened? But the auction purchase was complete in 2014. Kindly see not page number 27. On 31/2014, the state executed the certificate of sale after the disposal of the ring. But the matter which was remanded in the RRT, that matter was supposed to be decided within 3 months. It was not decided for 10 long years even after that. Suddenly, the department opened the file in 2020, issued notice. No notice was issued to Srinivas, and it decided the matter. In the meantime, what? By virtue of page 53, can you see page 53? Srinivas sold the property to me. I am the second purchaser. After the auction decisions were come, I was the purchaser.
No, but Vasudev is not a party here.
I was not a party.
So here,
He was not party to the
isn't it?
present DC.
No,
RRT.
no,
In the writ appeal, he was not a party.
no, the present treatment.
Vasudev, Venkatesh Iyer, I think he is, I think subsequently there was one more second. Sorry,
No, he's the second purchase.
second.
Yes.
This date not is at page 81.
No, no, he's in the same one. He's at page 55.
Yes,
He's the second purchaser.
V. Iyer, Venkatesh Iyer. Yes. Son of Venkatesh.
Yes.
Now, Lord, what happened?
What happened to the
In
DC?
the
DC.
DC order annexure A may be seen. The DC, can you see the cost item? Narayan Swamy,
Page?
page 21. Narayan Swamy is the first respondent. Muniyamma K. Nagesh and B.R. Srinivas. There were only 4 parties. Anyway, B.R. Srinivas had a right of audience. Now, at page 24, the court records various findings. The special DC court, it records the fact that in 2011 matter was disposed of. Then, kindly see page 23 bottom portion. Based on that, the RTC and other revenue records were affected in the name of the first respondent. Thereafter, first respondent family members have sold the schedule property to third respondent. OTA 17/4/2015, while registered document numbers were so. Since the date of purchase, the respondent number 1 is in peaceful possession and enjoyment of the property and his name has been mutated. Support of his contention is produced the copy of the mutation occurred in the order of the Assistant Commissioner. The fourth respondent impleaded in this. As he has not chosen to appear, notice has been taken by way of paper publication. In spite of that, he has not appeared and he has not chosen to appear. Therefore, we issued notice by paper publication. And all this, surprising blood is 2014 purchase. R1 sells it to R2 and 3 in 2014. The case is disposed of in 2011. In 2016, this land is sold by R1 in favor of R2 and 3. They incorporate R2 and 3 as parties, even after the disposal of the division bench. But they do not issue notice to the person, the division bench directs notice has to be issued. That plot your lordship will get. In the order sheet of the special DC, he opens this order sheet on 9/7/20. And within about 4 or 5 days, he passes the order without issuing notice to Srinivas.
Where is that order sheet?
That order sheet. Just about 3 or 4 days.
There's no entry regarding notice to Srinivas.
They say that on 24/8/2020, they locked him up. 24/8/2020. ಪ್ರಕರಣ ಕರೆಸಲಾಯಿತು R3 ಪರ ನೋಟಿಸ್ RPID ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲಾಯಿತು R3 ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ. Five 8/20 ನಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಆರ್ಡರ್ ಶೀಟ್ more order sheet. 5/8/20 ನಲ್ಲಿ ಪ್ರಕರಣ ಕರೆಸಲಾಯಿತು. R5 ವಕೀಲರು there is one respondent number 3 Shivkumar advocate who is signed also.
But I don't know, some on 30th September 2020, the first 3 lines, B.R. Srinivas Ravara Paravagi R. Gopal Krishna Vakilaru ದಿನಾಂಕ 24/9/2020 ರಂದು ಸಲ್ಲಿಸಿರುವ ಮನವಿಯನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ
ಏನಂದ್ರೆ ಫೈನಲ್ ಆರ್ಡರ್ 21/9/20 ಮಾಡಬೇಕು.
21/9/20
ಫೈನಲ್ ಆರ್ಡರ್ annexure A is dated 21/9/20. So ಮಾಡಾದ್ಮೇಲೆ perhaps they have gone and tried to invite the attention of the DC.
The order sheet doesn't tally.
And I think this
with
is the order sheet.
The proceedings.
Order sheet there.
No, now pursuant to the writ appeal direction,
Yes.
we must ought to have been notified. Where do you get it? What is the date? Sixteen? Next year?
Now the stated 24/9/20. RA. An impeding application he has sought to file on 24/9/20.
Our order is passed on
21/9/20.
to resolve subsequent. The application at annexure R7 is filed on 24/9/2020. Order is passed earlier to that on 21/9. You look at R7, it's dated 24/9 at page 47. Order is passed on 21/9 itself.
The second order sheet is opened in order to implead employee. The first order sheet clearly shows that there is no notice. Wait a minute. 21/9 the order is passed.
Correct, Monday, ಕೊಡೋಣ, but ಏನಿದೆ ಇದರಲ್ಲಿ? No, look at the wakalat. The wakalat you have produced along with your statement is dated 24/9/22. Order is passed on 21/9. First, we'll have it on Saturday. Come and complete Saturday. We'll have it on Saturday. Monday. Monday. Just get that typed copy of the order sheet.
Get it typed in.
There can be no proceeding once the final order is passed. Let it be redone after following the directions of the division bench. Relist the matter on 25th.
Alright.
You just make a typed copy of the order sheet.
There are two order sheets. One in the order was not. Then after we have tried the repeat. Both are. Right.
Now that after the division bench order, matter was sent back for reconsideration, isn't it? And that annexure A is passed after reconsideration. You are the purchaser from Srinivas.
Versus my options.
Now, in the present proceeding, Srinivas is not a party, is he? No, here, in the present writ.
In the 21/9.
No.
Because this transfer. I may have to see that also.
Or you can also get a power of attorney from Srinivas and have him included in the event there is no dispute between you and Srinivas. You find out. You find out. Fine, fine. Which one? 40. It's ready. Let us see. We'll give a date. They say it's ready. Statement of it is submitted that statement of objections will be filed. Relist the matter on 27th. On 27th. You serve it in advance so that they'll know what it is.
Then it is safe for me to allot a house. There, 1965, my father was allotted a land to an extent of 10 acres. Thereafter, one of the grantees, by name, one of the grantees challenged the said order, stating that the entire land which was supposed to be granted to him before the divisional commission.
The divisional commissioner set aside the order of the grant, telling that the DC did not have power. And thereafter, the special deputy commissioner gives the entire land for the public purposes and transfers it to the Department of Social Welfare Department in the year 1978. Thereafter, I approached the special deputy commissioner for grant of alternative land clearance. Thereafter, the deputy commissioner issued a letter to Tahsildar stating that consider his representative. Tahsildar issued a letter to Taluk Surveyor Village Accountant to conduct the survey, and they find out the land measuring 17 guntas and 20 guntas, which is out of Mandya city, and they have submitted a report to Assistant Commissioner. Even after that, AC and DC they have not taken steps.
Where is that report of the Tahsildar?
The next are L.
Just read it.
Page number 50.
We are seeking for implementation of this.
Implementation. Yes. Kindly take up annexure N, page number 2.
Correct. Let us see. Let them file what they want to file. Let them file on record.
Other grantees also approached this honorable court, and they have been by the virtue of order of this honorable court, their representation is considered. Page number serial. This honorable court has passed an order, Malad. Page number 54, Malad, annexure N. This honorable court has extracted the entire portion, Malad. Malad, may kindly come to page number 58, 57, Malad.
Let them file. Let them file. Let us. Statement of objections, if any, filed within 10 days. Relist the matter on 13th.
Right. Madam. Number 5 as a form of secretary filed by me.
Now they're only seeking for consideration of Form 53. We'll dispose it. within 6 months from date of constitution of the committee. Huh? The petitioner.
98 is pending. 3 months it will be very well.
Committee constitute
It transferred meeting ಆಗಿದೆ.
we have passed an order. Once it's constituted, within 6 months you have to dispose. Common order. Petitioners start for issuance of writ of mandamus. Direct respondent number 5. Consider application made in Form 53, dated 10/12/1998, Vide Annexure A, in respect of land bearing survey number 112, measuring an extent of 4 acres, situated at Tuppadamadu village, Kaspa Hubli, Nagamangala Taluk, Mandya district. And pass orders for regularization of unauthorized occupation. The learned VGA submits that this code in WP 13781 of 2023 has passed certain observations at paragraph 3, Roman 1 to 3, Roman 3, which and the present petition may be disposed of, taking note of the observations made in the said writ petition. Next. The observations in WP 13781 of 2023 at para 3, Roman 1 to 3, Roman 3 reads as hereunder. In light of the same, present petition is required to be disposed of. If the committee is constituted in terms of the direction at Roman 1 extracted above, Form 53 filed by the petitioner is to be disposed of in terms of direction at Roman 2 extracted above within the period of 6 months from date of constitution of the committee. Needless to state, the respondents are entitled to take note of all records, circulars, etc. when considering the claim, and the direction is limited only to consideration as per law. Accordingly, petition is disposed of.
Number 43 answer. 3 to held by the video was constituted under their second number proceedings.
So we have said that within 6 months.
3/23 the thing was there.
One sentence. It is submitted that the committee has been constituted.
Constituted under the report is also there. Page number 48. 43. There were 3 meetings were held, my lord, no action. My land.
Accordingly, proceedings to be concluded within 6 months.
My lord, no.
Needless to state, till decision is taken on the application of the petitioner, petitioner's enjoyment and possession ought not to be disturbed.